Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance and who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Good morning. Welcome to the second day of our spring oral argument session here in beautiful downtown Pittsburgh. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In 2022, we celebrated the court's historic 300th anniversary in Philadelphia. We on this bench are very proud of our court's history. We sit today in Pittsburgh's City County building, a 1917 granite Art Deco building, which was designed by renowned local architect Henry Hornbostel. The City County building houses executive, legislative, and judicial offices for both the city of Pittsburgh and Allegheny County. Architect Edward B. Lee was responsible for the design of this magnificent courtroom. The wooden oblongs, the fluted columns, and the bench and bar are all mahogany. Behind the bench is a beautiful mural of the state coat of arms. The same coat of arms is carved into each of the justices' chairs, and individual elements are represented in wood medallions on the bench, specifically a ship carrying the state's commerce to the world, a plow working our rich natural resources, 3 golden sheaves of wheat representing our state's fertile fields and our citizens' wealth of human thought and action. And finally, an American bald eagle demonstrating Pennsylvania's loyalty to the United States. The murals in this room were all painted by local artist Edward Trumbull. On the ceiling, you will see 3 great lawgivers, all framed by gilded plaster. They're placed there so that if you look up during the arguments, we won't think you're bored. We think you're looking at the artwork. Furthest from the bench is the Byzantine Emperor Justinian, famed for the Reformation and codification of Roman law. In the center is Moses, seated and holding the 10 Commandments. And finally, closest to the bench is the English King, Edward I, who spent much of his reign reforming the common law. To the left of the bench, you will see a mural depicting William Penn, founder of Pennsylvania, and to the right, William Pitt, the first Earl of Chatham, who was held in high esteem by the American colonists after publicly supporting many of their positions. The city of Pittsburgh, as you may know, is the namesake of William Pitt. It is truly an honor to sit and work in 3 beautiful courtrooms in Philadelphia, Harrisburg, and Pittsburgh. Our court is always pleased to welcome students, and today we have with us some students from Duquesne Law School. They are first-year law students and very impressionable. So when you argue today, attorneys, please try not to dissuade them from their future career plans in law. We also have some undergraduate students from Duquesne University, and they are in the Intro to Law class with their professor, Megan Montcalm. So would Professor Montcalm and our students please stand so we can acknowledge you? Welcome. We're happy to have you with us. You may be seated. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of your case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for any particular issues. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we wish to explore further. I remind you that in our court, we do not permit rebuttal. Finally, while we have no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Thomas and Stacy Ansell versus Charah Solutions et al. Representing appellants, Mr. John Kane. Representing Charah Solutions, Ms. Laura White.
In June 2023, Aplts imploded 2 chimney stacks on the site of the Cheswick Power Station in Springdale Borough, Allegheny County, resulting in an air blast that projected toxic materials into the surrounding residential neighborhood. Months later, Aplts sought to implode the boiler house of the same power station. The Department of Environmental Protection granted Aplts' second blasting permit. That same day, nearby residents filed a complaint in equity in the trial court seeking to enjoin the boiler house implosion. After holding several hearings on the matter, the trial court granted the residents' motion for a preliminary injunction. The Superior Court reversed, finding that there were adequate administrative remedies that residents were required to exhaust before they could seek equitable relief before the trial court. In this appeal, we consider whether the Superior Court erred in ruling that residents, after successfully proving entitlement to injunctive relief, should have first exhausted their administrative remedies. We also granted review to address whether the Superior Court erred in distinguishing our 2002 decision in Machapongo Land and Coal Company, where we held that a trial court properly prohibited blasting to prevent a nuisance despite the existence of a valid blasting permit. Please proceed. Good morning.
Good morning, Your Honor. May it please the court, Madam Chief Justice, Justices, Counsel, John Kane on behalf of the plaintiff appellants, various residents of Springdale Borough. I have my co-counsel, Janice Savinas and Michael Gallucci back with the clients. The issue here is that the Superior Court erred in determining that the trial court lacked jurisdiction under the exhaustion doctrine. There are several exceptions to the exhaustion doctrine, namely, you're not required to exhaust administrative remedies if those remedies are unavailable, inadequate, do not cover the grounds upon which you are seeking, or if the plaintiff will be irreparably harmed by attempting to go that route. Although we only need to prove one of those exceptions, each one of them we can establish very easily in this matter. The first issue was whether or not administrative remedies were available. We contend that they were not available. Superior Court erred when it ruled that administrative remedies were available because there's such a thing as a supersedious. Unfortunately, Superior Court was not considering the actual facts in this case and simply acknowledged that there is a supersedious. If you go back and look at the date that Your Honor mentioned earlier, September 15th, 2023, on that date, the Pennsylvania Department of Environmental Protection granted the blasting permit, allowing the defendants to implode the boiler house. We learned about that permit on that day, September 15th, and we did everything we could, scrambling to get a complaint in equity filed on that date, because we learned they were going to be adding explosives to the boiler house over the weekend. So we knew time was of the essence, and we had to act or we would lose any chance to get our clients the justice that they sought and that they deserved.
What actions did you do on the 15th when you found out the permit was granted to try to contact DEP to seek a supersedious?
So we took no actions to attempt to do a supersedious because we literally were scrambling from the moment we learned the blasting permit was approved to calling each of our 16 different plaintiffs to tell them that the blasting permit was granted, to discussing what they wanted to do, and then we had to call the courthouse to see, can we even get a motion heard on Monday? Because that is how critical time was. So we found that Judge McVeigh was available, or I don't even know if we knew it was Judge McVeigh at that time. We just knew that there was a motions judge who would be available to hear an emergency motion on that Monday. So we filed the complaint in equity, filed a motion seeking an emergency motion for preliminary injunction, seeking to have this issue heard.
Counsel, I think I understand that you scrambled. That's the nature of every permit that's issued. People who oppose it scramble. I think Justice Mundy's question was, why did you scramble to go to common pleas? Why didn't you scramble to go to the Environmental Hearing Board?
If you look in the reproduced record at 2275, that is the letter that was issued by the Pennsylvania Department of Environmental Protection granting the permit and allowing individuals to appeal within 30 days. So that record itself, we didn't even have that on that Friday. We're going by word of mouth, and so we did not have anything telling us when to appeal, how to appeal, whatever.
You're a lawyer. You know how to appeal a permit issued, and the rules governing the Environmental Hearing Board have rules just like the rules of civil procedure on supersedious. I mean, for all intents and purposes, the Environmental Hearing Board is a court. And the concern, I think the question raised here and raised by the Superior Court is you went to the wrong court. That's really the point. You had a court to go to, you went to the wrong one.
So, respectfully, I would disagree because I don't believe there was time to do that. I understand you're indicating we could have filed an appeal there, but if you look at the actual regulations dealing with that, so you have a 30-day appeal period. You have the possibility of getting a hearing on a supersedious within 14 days if feasible. So when we're faced on Friday afternoon with the implosion occurring 5 business days later, a week later on the following Friday, and we look at the rules and we see it's a 30-day appeal period, that they cannot grant supersedious absent a hearing. And
No, the rule provides for a temporary supersedious. It applies the rule. The Environmental Hearing Board rule does provide for a TRO with a hearing to follow, which is exactly what the rules of civil procedure provide.
Understood, Your Honor. When we looked at the regulations, I simply don't think there was enough time to get somebody. We couldn't guarantee that we could get somebody to even look at an motion before the Environmental Hearing Board in sufficient time.
You didn't try. That's the point, is you didn't try. And I mean, that's why you're here, and that's why the Superior Court did what it did. I guess the question is that I have for you as counsel is, did you even consider it, or did you just go full board, we have to go to the Court of Common Pleas?
We looked, we considered, we didn't think it was feasible because we literally had to stop them from placing explosives by Monday morning. When we showed up at the courthouse Monday morning at 9:30, the defense counsel was already saying, it's too late to stop this process.
Well, defense counsel always says that. I mean, that's why we have lawyers and we have judges and we have Environmental Hearing Board judges.
I understand, but we needed somebody. Every moment we wasted not being before somebody who could stop this was putting our clients further and further and further at risk. We did not believe we were going to be able to get in front of a hearing in the Environmental Hearing Board within time to get them to stop. By Wednesday, so we had the initial motion on Monday morning at 9:30 when they were already saying it's now too late to even move forward, to even stop us from going forward. Judge says, well, I'm going to schedule a hearing. Let's take a look at this 2 days from now on Wednesday. We showed up on Wednesday, and defense counsel again said, look, we're at the no return point. We can't, if this issue isn't resolved by today on Wednesday, the implosion is off because that's how critical this is. That's how unsafe it is. And that's after the judge on Monday ruled that they had to cease placing explosives. So on Monday morning, when they were arguing that it's already too late, that it's already too dangerous, that this situation is hazardous, to stop them now would cause more harm than allowing them to move forward, the judge entered an order saying, stop placing explosives.
Counsel, could you have raised all of the issues that you raised in the Common Pleas Court before the Environmental Hearing Board?
I don't believe so. One of the other grounds upon which...
Let me just get the procedural. In order to get a supersedious, you would have had to have appealed from the issuance of the permit, correct?
Correct.
Are there specific grounds statutorily upon which to base such an appeal?
So what we found that when we looked at this, and some of this, we were hearing, on the side, and some of this we even learned during the hearing. But if you look at how the issue's set up, the Department of Environmental Protection only deals with the blasting end of things. They don't deal with anything other than, can you blow it up? That's all they're dealing with. So that would require an appeal of the Pennsylvania Department of Environmental Protection to just the issue of a blasting. The Department of Environmental Protection defers all other issues related to the dust, the danger from the dust. They defer that all to the Allegheny County. So it would require a separate appeal of the Allegheny County clearance document. So they issued eventually a clearance giving the DEP the go-ahead. Okay, we're clearing it now. You can grant the permit and blow up the building. So it's two separate appeals that we'd have to deal with.
Counsel, in answer to Justice Donohue's question, which I think is the central theme in this particular case, you started off by saying that the appeal to the Environmental Hearing Board doesn't give you necessarily the ability to enjoin the public nuisance requirements. I guess the question is, does the DEP, Allegheny County, or even the Environmental Hearing Board, did they review the environmental hazards? I mean, this is a public nuisance complaint about environmental exposure, damage to property owners, other ability or other issues. Can those issues even be kind of brought up to DEP or brought up and reviewed by Environmental Hearing Board?
Not according to the DEP and the Allegheny County Health Department. They themselves said, what you're asking for, we don't control, we don't govern. You're saying that you are potentially exposed to these hazardous RCRA metals that are emanating from the boiler house once the explosives are used. We don't govern that. We never look at this. All we care about, DEP cares about blasting, Allegheny County Health Department cares about asbestos, and there's nothing in between.
Counsel, respectfully, that's not completely accurate. The permit has conditions. All permits issued by DEP to engage in blasting have conditions, and the permit was advertised. I assume the application was advertised by DEP for the permit in the Pennsylvania Bulletin, probably.
I couldn't answer that, Your Honor.
Usually permits, when they're applied for by DEP, are advertised, open for public comment. Sometimes they have public hearings, not all the time, but your clients had an opportunity to submit comments publicly to the permit application that DEP published in the Pennsylvania Bulletin. And then the permit gets issued. It didn't just say, thou shalt go and blast. The permit probably had conditions, right?
I don't think that it did, Your Honor. I know that they discussed different issues, but essentially all they were concerned with was the blasting.
Well, you keep saying that, but the permits have conditions in terms of how to safely blast. If you do this, you will do this screening, or you will do something like that. They have those conditions, right?
You're correct, Your Honor. Yes.
Right. And when you appeal a permit grant to the Environmental Hearing Board, the hearing board doesn't really care what DEP did at that point in time. DEP is usually defending its permit in front of the Environmental Hearing Board, and the objector can argue for greater conditions to address public nuisance issues, environmental contamination. That's how this process unfolds, isn't it?
Well, if I could go back to your first point, which you're saying that my clients had the ability to speak up and to oppose this, I don't believe that they did. I can't stand
You don't think this permit was not published in the Pennsylvania Bulletin?
I can't honestly tell you that I know one way or the other. I don't know. But what I can tell you is that when in the hearing, we learned that all of this was going on behind closed doors, and none of this was put up by the Springdale Borough, nor was it spread out to the public. So at the hearing, we had 2 Springdale Borough Council members testified. They were there to watch. We called them as witnesses. They both testified. We knew nothing about this demolition permit. This was not passed before us. We didn't vote on this.
Well, DEP or your opposing counsel has a big issue if this application was not advertised in the Pennsylvania Bulletin. That is a big problem. I'm not sure you raised that issue, but it's a big problem.
Mr. Kane, with respect to the exhaustion of remedies, you're not asking us to create some new exception to the exhaustion doctrine, are you? You're asking us to recognize an established exception, the inadequacy of the other remedies.
That's correct.
Okay, before you answer, could you answer my question?
Sure.
Which I think gives you the predicate to answer this. Could you have gotten the same relief before the Environmental Hearing Board that you wanted, that you sought in the Court of Common Pleas?
I don't believe that we could have.
There you go, inadequate alternative remedies.
And what was it? What couldn't you do?
We wanted to stop them from blowing up the boiler house building due to the toxic nature of the building, to stop them from imploding it and spreading their dust off of their premises all throughout the community onto all of the residents' property, destroying homes, destroying personal property, endangering their health.
That would be implicit in anybody imploding anything, that one would hope that they didn't plan on doing any of that. But why is it that the Environmental Hearing Board couldn't have heard that request?
So first, if I would deal with the timeliness of it, I still don't believe that we could have gotten there
That's
fast
a
enough.
different issue. It's a different issue. I'll take your word for it. What could they have given you the relief that the Court of Common Pleas ultimately gave you?
I don't believe so, and I understand Your Honor saying it's a different issue, but when the past courts have looked at that third exception to the exhaustion doctrine, it has many different parts, any one of which is sufficient to say that the trial court would retain
Even timing,
jurisdiction.
if they can't act on it timely enough, that's the same as an inadequate remedy, isn't it?
Correct. And if we don't think that we could have gotten there fast enough, that causes irreparable harm to the plaintiffs, which is another part of that exception, that the trial court doesn't lose jurisdiction if plaintiffs, having gone after the administrative route because they couldn't have that remedy they sought, or there wasn't time to do it, or the remedy wasn't broad enough to encompass what they were asking for, all of those fall into that third exception to the exhaustion doctrine. So in that regard, I think we easily satisfy that. And one thing that we haven't talked about here is the unclean hands of the defendant. The trial court ruled that they lacked clean hands in this matter because they had started doing demolition work prior to receiving the blasting permit. They didn't demolish it, obviously, but they had cut into the support I-beams. They had placed explosives before the permit was granted. And the trial court ruled in its opinions that their actions, their unclean hands, limited the remedies the trial court could then try to envision under its equitable powers. So this was a situation where even the trial court itself, under its broad equitable powers, was limited in the relief that it could provide because of the unclean hands of the defendant. And so when the Superior Court says that after plaintiffs have gone through a 3-month hearing, more than a couple of weeks of actual testimony, hundreds or thousands of exhibits, establishing entitlement to injunctive relief, to say that the trial court now loses jurisdiction when it's the unclean hands of the defendant that is limiting the court is simply unjust and inequitable. And when you look at the actions of the defendant, the trial court's opinion notes that they had been in this process since 2022. So they had started this process back in 2022, and yet they're trying to implode a 15-story building chock full of all sorts of hazardous materials on 5 business days' notice.
Counsel, the boiler house has been imploded, or it's gone, correct? Or
It was mechanically demolished, yes.
what is it that you want us to do?
I want you to rule that the trial court had jurisdiction, because one of the big issues here, this is not a question of, oh, this issue is moot or this is an advisory opinion.
Well, it is kind of a question of, is it moot? I mean, that's a question.
Well, I would say that it's not moot because we had to put up a bond. Our clients had to put up a $50,000 bond in order to get the injunction hearing. The defendants are all arguing, hey, we're entitled to that $50,000 because the injunction was dissolved. Now we are entitled to that $50,000. And in fact, our clients have been sued by the defendants, claiming $750,000 in damages due to the injunction hearing. So they are suing our clients, saying we have broad damages, far more than the $50,000 that the court required you to post as a bond. We have damages far exceed that. Whether the trial court had jurisdiction or didn't have jurisdiction is critical to that issue. If this court were to look at it and say, we disagree with the Superior Court, the trial court absolutely had jurisdiction, that changes the landscape of both of those issues. Are our clients entitled to the $50,000 back that they had to put up to save their homes? What are their defenses to the defendant's suit against them, saying you owe us $750,000 because you prevented us from imploding the boiler house? So,
Well, and our decision, if we write an opinion on this as to whether you were permitted to go straight to common pleas court, is an issue that has some enduring value. It's not just pertaining to this case. I can see that issue recurring.
and there are about 7 different types of litigation that all stem from this issue. There's bad faith lawsuits against insurance companies who haven't paid their claims. There are subrogation claims against it. There's a damages complaint that's been filed against the defendants for all the damages that are sustained. So there's at least 7 other types of lawsuits all stemming from this same issue. So the ruling of this court on whether the trial court had jurisdiction will play a factor in every one of those different types of litigation. And when your honors looked at the records here, these were, Judge McVeigh spent a lot of time and expertise writing 2 lengthy opinions, having findings of fact and conclusions of law, all of which are essentially written in stone as findings of fact and apply to all the future litigation, all those other 7 different cases, if he had jurisdiction. And I'm certain counsel will argue, if this court says he didn't have jurisdiction, then those findings of fact are out, and you have to redo everything. You have to put all the same witnesses back on. You have to establish all the same facts. When the trial court spent 3 months, countless hours and weeks dealing with this, it would, again, be inequitable to say that the trial court lacked jurisdiction when it was the defendant's own timeline. It was their own, it was by design to race to implode this. They could have set the implosion 6 months in advance. They could have given the people of Springdale a chance to
Well, but they
object.
were, counsel, they could have done that, but they weren't obligated to do that. They had a permit in their hand, and there was a process. I'm sympathetic to your clients and their need to get a quick remedy here, but we have precedent dating back to 1980 in Canonsburg Hospital that says, you can't go to the courts in equity and bypass an administrative remedy. But let's take the case that's in front of us. Tell me what the legal principle is that you want us to adopt to undo the ruling in Canonsburg Hospital that's been in place since 1980 and say, under this particular circumstance, you can go to the court in equity and bypass an administrative remedy. Is it exigency? Because in every permit case, there's an exigency.
So I don't want the court to adopt any new rule that Your Honor is suggesting. I want the court to follow the cases that I cited: Empire Sanitary Landfill, Rehab Community Providers Association, Ohio Casualty Group. All of those provide the same exceptions to the exhaustion doctrine, which I think we easily meet from any number of different factors, from the timeliness of it, from the inadequacy of it, from the irreparable harm.
You never did answer Justice Donohue's question is, what relief were you seeking in common pleas that you could not have gotten from the Environmental Hearing Board?
We were seeking for them to not create a nuisance of toxic material that would leave their premises and to go on to the plaintiffs.
By doing what? Stopping it or putting conditions on it?
By stopping it, and eventually the trial court said by putting conditions on it. We just
You're
wanted
saying
them.
the Environmental Hearing Board could not have stopped it, could not have reversed the grant of the permit, and could not have put conditions on the permit?
What I'm saying is the DEP and the Allegheny County Health Department themselves said they don't govern this. They don't look at any of this toxic material other than
I'm not asking about DEP, I'm asking about the EHB. You're saying the EHB could not have reversed the grant of the permit by DEP, could not have put new additional conditions on the permit. You're saying the EHB lacked the ability to do that.
I would say that from a straight timeliness argument, they lacked the ability to do it. That there was not
Okay,
time.
so you're saying that if there were time, the EHB has the authority to grant that relief. So the only reason, it's not that they couldn't grant the relief, it's because you believed that there was not enough time to get it.
We believe that there is not enough time, and we believe that they did not provide an adequate remedy to the plaintiffs because they were not governing the issues that the plaintiffs found themselves in. Specifically, the RCRA metals that were in the smokestacks and were also in the boiler house. These metals are not governed. They're not, while the federal law calls them RCRA metals and acknowledges that they're toxic, neither the DEP nor the Allegheny County Health Department concerns themselves with it. They themselves said, when somebody blows up a building, we don't worry about what's inside of it, whether that's going to become aerosolized and whether that's going to poison the people around it. That's not our job. That is not something that we govern. So what I'm saying is that specific issue, the governmental bodies themselves, they say, we don't deal with that. If you're worried about somebody blowing up a building and something inside of it becoming toxic when it's aerosolized, that's not us.
Counsel, you repeatedly say in your brief that you didn't challenge the permit. I mean, there were timeliness issues, things of that nature, but you also say there is no basis to challenge the issuance of the permit.
Right, and the reason...
What does that mean?
So...
If it doesn't mean you couldn't get the relief that you were asking for.
And I apologize if I've been unclear, but that's essentially what I'm circling around, is that we didn't challenge the permit itself because they don't govern these issues. So the DEP...
What does that mean? Does that mean in order to challenge the permit, you have to point to a defect in its issuance? Is
Yes.
that what your argument is?
Yes, that they say that by regulation, they had no discretion to deny the blasting permit. That's what they testified to. They say, the issues that you're complaining of are not things that we are by regulation required to look at, and so we didn't. And we could not deny the permit because we don't have any regulations regarding the issues that you're bringing to us.
Counsel, can I back you up just 1 second? You represent a community group, a group of neighbors that are going to be affected by aerosolized toxic chemicals. Do they even have standing to challenge the issuance of a permit? Because in my experience doing municipal law back in another lifetime, the issuance of a permit is usually from the township or the issuing authority to somebody that wants to blast something. I've never, does a neighbors group have the ability to even issue an appeal?
Your Honor, I honestly can't say I've looked it up. I don't know. That certainly is a good point because...
Usually a company applies for a blasting permit. It's to the government official. The government official then issues the blasting permit or denies it. Somebody from that particular denial or grievance files the appeal. I'm just kind of thinking to myself, does a neighborhood group have standing to appeal the issuance or denial of a blasting permit?
The letter from the DEP, which is 2275A in the reproduced record, states that anyone aggrieved by this decision may appeal to the Environmental Hearing Board.
We've got, I mean, there's history on this particular issue in the Machipongo decision in the Tinicum Township case, where the issuance of a blasting permit has been appealed to the Court of Common Pleas via a public nuisance. So I'm just wondering the difference, because Justice Brobson's pointing out what the standing of the Environmental Hearing Board has and what remedies they can issue as opposed to what the courts of common pleas can issue. So my thought process is that does a neighborhood group that's going to be affected by the blast itself, do they have the ability to actually go to the Environmental Hearing Board as opposed to seeking their equitable remedy in the Court of Common Pleas?
So I can't say I've honestly looked at that particular issue in that sense. I was really relying on the appeal letter, which we didn't receive until we were in the middle of the hearing, to find out that they say anyone aggrieved by it could have appealed to this.
That's my point really is, Justice Brobson points out that when you have a blasting permit, the advertisement goes in the Pennsylvania Bulletin. I don't know about you, but I don't spend my mornings reviewing the Pennsylvania Bulletin for blasting permits, and I'm sure your clients don't either. Your clients probably get wind of it when a blasting permit's issued, somebody said something in the township, and it gets back to them. That's what kind of triggered my thought process on that issue.
Right, and if there was a
I mean,
notice.
is there a notice requirement? In other words, this particular company applies for a blasting permit through the township or the DEP in this particular case. Did your clients even get notice of it?
So the defendants had put out a notice in the week before the permit was granted that we're going to blow up the boiler house.
Notice to who?
They were passing out flyers. No, they gave notice to the Springdale Borough Police Department. And then somebody heard from somebody that, hey, I hear they're blowing up the boiler house. So then we started getting calls. And so we then started calling around trying to reach people. And we were calling the Department of Environmental Protection. We're calling somebody. And when we reached the Department of Environmental Protection, they indicated we haven't granted any such permit. So we have somebody saying they're going to do something, but they don't have the permit that's granted. And so we're all trying to figure this out in the days leading up to the granting of that permit. The DEP itself says we have granted no such permit. So there was a notice they were going to do something, but it had not yet even been approved, which brings us back to this 5 business day thing where we learn on a Friday through hearsay that they granted this permit, haven't seen it, and are scrambling to react to the concerns of all of these people whose homes were all damaged, destroyed, etc.
By the first blast.
By the first blast, right? And that's the reason we were even involved, because we were getting ready to file a complaint for that issue to try to get these people damages from the June 2nd. Then we get these phone calls all that week leading up to the blasting permit, and we're trying to figure out what's happening here. And so that's where we thought we need to stop them from placing explosives. An emergency motion for injunctive relief it's a very, very high standard, but we met it because of the circumstances here.
I think that might be an important issue for you to kind of think about. I mean, the applicant applies to the township or the DEP for a blasting permit, and then if it's granted, one party can appeal. If it's denied, the other party can appeal. I'm just curious as to whether or not a neighborhood group even has standing to appeal the issuance of a blasting permit to the Environmental Hearing Board, as opposed to seeking the relief that you sought in this particular case through equitable means in the Court of Common Pleas.
Prior to the blasting permit, there was a demolition permit issued by, theoretically, Springdale Borough, but it actually wasn't voted on by Springdale Borough, and that's why we called 2 of the council members.
That deals with the issuance of the Sunshine Act. When you finally got into court, you realized what was going on. The blasting permit was issued without public comment. Is that what you're?
Yes, that's exactly what I'm saying. Right. So everything is happening without adequate notice. We have no adequate notice of anything. And so we're basically scrambling. We learned in the hearing of this demolition permit that the council members themselves said, we just heard about this in the last couple of weeks. We didn't know that this was passed, and we never voted on it. And you have to vote on the amount of money that you want to, when they approve a demolition permit, the big issue is the cost. What is the cost that the borough will endure from the demolition that you're going to put? They have to hire police officers. They have to hire people to clean up. They have to do all these sorts of things. And the borough was supposed to be able to vote on the cost. And the individual.
That's the big issue to the township. I imagine your clients, the big issue to them is making sure toxic chemicals don't get into their lungs, get into their families, affect their children.
1,000%.
Mr. Kane, is there anything else you want to say about Tinicum Township or Manchapongo?
So, with respect to Manchapongo and Tinicum, I understand they went through the environmental hearing board process in those cases, and we did not hear. But the conclusion at the end of it was that even a validly granted permit you're still allowed to seek injunctive relief, even though there's a validly granted permit. And so we never challenged the permit when we looked at it, and they said, "Hey, we don't govern RCRA metals. We don't do this." So
you're changing the facts, though. You said you didn't find out about the "we don't govern RCRA metal" thing until you put the DEP person on the stand. You filed the lawsuit before you knew that.
I agree. But I'm saying when we look at what they say, we didn't have any basis to challenge it on Friday afternoon when we hear they granted the permit and we've not seen it. We don't know what they looked at. We don't know what this permit entailed. We had the old permit from the smokestacks, and they violated that blasting permit in 16 or 17 different areas. But we don't have that because of the inadequate notice that was provided to everyone in this matter. Thank you, Your Honors.
Thank you very much. Let's hear from your opposing counsel. Ms. Veith?
May it please the court, my name is Laura Veith, and I'm joined today by Dave Raphael, Jay Kober. We represent Apelli Charah Solutions, Inc.
Ms. Veith, could you come closer to the mic or maybe pull it up a little bit? Yeah, there you go. Thank
Is that
you.
better? Okay. Also, counsel today is Julie Brennan on behalf of Grant Mackey Demolition Company. As the justices have noted, this case is about whether a court of common pleas sitting in equity had jurisdiction to enjoin permitted activity when plaintiffs bypassed every administrative remedy available.
Let me ask you, speaking of permitted activity, your clients intentionally weakened the boiler house structure before the permit was issued. Is that correct? That's my understanding of the record.
So, Charah Solutions is the parent company of the property owner here.
Sorry, could you repeat?
Charah Solutions is the parent company of the property owner here. Charah Solutions, in turn, hired Grant Mackey Demolition Company to conduct the demolition at the site. There were several buildings on the property. Grant Mackey's job was to demolish all of them, some of them by conventional means, some of them by implosion. For the implosions, Grant Mackey in turn hired CDI to conduct those implosions. My understanding from Grant Mackey is that in demolishing buildings, you don't just prepare it overnight. So for months, several things were going on at the site and several things were going on with respect to the boiler house. Number one, asbestos abatement. That occurred over the course of roughly 11 months within the boiler house. Number two, they were stripping out other things from the boiler house. Just by illustration, the boiler house is a 12-story building. It's huge. And so to...
I remember it. I remember it. I'd pass it on my way to Jean's Custard.
I did too. So to prepare the structure for demolition requires a lot of work. As part of that, the first 3 stories of the building were completely emptied. And up from there, other things were taken out of the building as well. Part of that exercise is placing cuts in the building. Number one, to remove equipment, but number two, to also prepare it for demolition. These things are done whether the building is imploded by conventional means or by implosion. They're necessary steps to make sure that the building can be imploded on schedule. And they have to take place, you know, some cuts are made the day of, some cuts are made weeks before, some cuts are made months before. That's my understanding.
I fully understand that there's a lot of prep work involved. The reason I ask the question is it certainly appears like the creation of facts on the ground in the sense of a fait accompli, because once would you agree that it appears to presume the issuance of a permit, that a permit would properly be granted, creating an inevitable circumstance where everybody would have to live with the inevitable creation of the outcome your clients wanted? In other words, would it not have been proper to await permitting before commencing actions that made the demolition inevitable?
My understanding is Grant Mackey could have. I don't know if that would have sacrificed the September 22nd demolition date. And when demolition dates are set, you know, these are highly regulated events.
I'm sorry, I don't mean to cut you off, but you've said now a lot of work went in, and these are highly regulated events. So the question that keeps coming back into my mind, and I think it kind of is circulating throughout this particular discussion, is when Grant Mackey or PBI applies for the permit, the demolition permit, is part of that permit application an environmental safety plan? Because I think if I'm living across the street, or if I'm going to get some custard with Justice Wecht, I'm a vegan, by the way, I don't eat custard. But
It was Glenn's, not Jean's, my mistake.
so if I'm living across the street, all of this is very interesting, but what my primary focus is going to be, I want to make sure that my kids, my family, we don't suffer the inhalation or the aerolization of these toxic chemicals. So when that building blasting permit goes up, because we're going to talk about what the jurisdiction of the DEP is, the Allegheny County Health Department, the Environmental Hearing Board, did you submit an environmental safety plan to make sure that as part of this demolition, this is not, these toxic chemicals are not going to be aerosolized and are not going to blast into the neighbors? Because to me, if you did and the neighbors had a chance to look at it, DEP had a chance to look at it, the neighbors had maybe their own safety consultants, and they reviewed it, and then the Environmental Hearing Board also reviews it. But if the Environmental Hearing Board, DEP, and Grant Mackey or PBI only care about, we want to make sure that whatever blast that happens will take down this building, and we don't care about the aerolization, we're talking apples and oranges. Do you understand where I'm going with this case?
I do, Your Honor.
I want to make sure the neighbors are safe. And I want to make sure the building, if the blasting permit is given, I want to make sure the building comes down safely, it's not aerosolized, and nothing gets into the neighbors.
Your Honor, every party here shares the same interest, and that is that the blasting occurs without causing harm.
Right.
What the plaintiffs are arguing is simply they're not aware of the regulatory process that was in place.
My question is very simple, and I don't care what the plaintiffs are arguing. My question is very simple. As part of this demolition permit, blasting permit, was an environmental safety plan prepared and disseminated and part of the plan?
Yes, Your Honor. So this is the permit for the blast. The plaintiffs complained they didn't have it on the Friday. I can represent to you they had it on the Monday in court.
Is that in the record? Could you point me to?
Yes, it is. It's R2275A, and it was Defense Exhibit 3 in the preliminary injunction proceeding. Justice Robson, as you noted, applications are and permit issuances are very detailed documents. To your question, Justice McCaffrey, the DEP conditioned its approval of the blast permit on the Allegheny County Health Department's approval of an air pollution plan. So the idea that the Allegheny County Health Department does not regulate dust or toxic dust is not true. It does by statute, by mandate simply by mandate, and also in this case it exercised those obligations. So this permit that the plaintiffs had on the Monday when we were in court provides, enclosed is the above referenced blasting activity permit. As a courtesy, a copy of the dust mitigation and control plan approved by the Allegheny County Health Department is also attached. And the DEP goes on to say that the department does not enforce the dust control plan. That plan is within the Allegheny County Health Department's jurisdiction.
Counsel, do I understand that the 11 months of preparation, the removal, the cutting of the slices, was that all done before you were requiring or requested a permit?
The asbestos abatement was complete before the demolition was set, but the way the asbestos abatement works is the Allegheny County Health Department issued several permits for several different areas of the property, some of which related to the boiler house. One of the conditions in this very permit is that all of the asbestos work had to be completed and all of the Allegheny County Health Department permits had to be closed before the blasting permit would be issued.
Once that permit that you're showing us there, once that permit was issued, was there anything that DEP or the EHB could do to rescind it on the basis of nuisance?
Yes, Your Honor.
What would that have been?
So both the DEP and the Allegheny County Health Department are concerned with abating or avoiding nuisances. They are charged with ensuring that nuisances don't occur in this Commonwealth. So the plaintiffs had two avenues here. They should have, number one, appealed the blast permit. To answer Justice McCaffrey's question, yes, they have standing. Any aggrieved party has standing. And so that's simply not an issue.
Proper notice was issued in the Pennsylvania Bulletin.
My understanding is it was. I don't have any, I haven't seen it, but I don't have any reason to believe that it wasn't. Further, the plaintiffs had notice that.
Oh, wait a minute, go back a minute. Is there anything in the record that is going to tell us whether it was?
What I can tell you is the plaintiffs knew that the blast permit was being considered and that it was going to be issued.
When?
They talked a lot about the Friday that they filed their complaint. And that complaint was actually 34 pages. And so, you know, they mentioned that they were in a huge hurry to get this on file, to get a judge. What they don't tell you is they could have filed this exact same complaint electronically with the EHB. They just elected not to do it. But in this complaint, Justice Todd, they mention in paragraphs paragraphs 69, 70, 71, and 72 of the complaint that they filed on September 15th, the day they say they got the permit. In that complaint, they allege that they were aware of, on July 21st, 2023, that CDI had to file a corrective action plan with the DEP, and that was mandated following the June 2023 chimney implosion. In that corrective action plan that the plaintiffs had, CDI indicated that the plan was to implode the boiler house on September 22nd, 2023.
I have a question for you, Counselor. You said they could have gone to the EHB. Share it with me. Does the EHB have declaratory power or the power to grant an injunction?
It's called a supersedious before the EHB, and it would have prohibited the demolition of the imploding of the boiler house. The EHB, their mandate is a narrow one, but it is squarely applicable here. Any appeals relating to a permit issuance by the DEP must go to the EHB. That's clear. From there, the EHB's review is very broad. As you know, the blasting permit here had many, many conditions. Sorry.
Again, I think we're kind of comparing apples and oranges. The EHB has jurisdiction to hear an appeal from the issuance of a permit. What if the issuance of a permit is going to create a public nuisance?
So, Your Honor,
nobody's going to say, yeah, go ahead and blow it up, and if the neighbors, get sick and get cancer and die in 20 years, we'll deal with it then.
There is no authority in this Commonwealth to contend that a litigant can bypass administrative remedies that are available that would provide adequate relief. Those administrative remedies must first be exhausted.
That begs the question that I asked earlier, which is about the air pollution plan, the Environmental Hearing Board, and what the Environmental Hearing Board can and can't do. The reason I'm asking this question is, and I don't want to pull the rug out, but I just thought, December 10, 2003, Judge McVeigh issued his order. It grants a preliminary injunction. It requires the party to attempt to agree on a joint comprehensive safety plan, submit that plan to DEP and Allegheny County Health Department for review input, hold a public meeting on the plan, and request that the DEP, quote, condition the approval of the blasting permit on meeting of the terms of the joint comprehensive safety plan. Did that meeting ever happen? Did you guys meet with the plaintiffs and develop this joint plan to submit to the court, Allegheny County and the DEP? Because if you did, I would imagine we wouldn't be sitting here, right?
I'm sorry, you're wrong, Your Honor. Yes, we
Won't be the
tried.
first time.
We did try. So that order, we believe the Superior Court correctly held that the trial court did not have jurisdiction to enter that order. There are several problems with that order. Chief among them is that the court entered an injunction and then held that there were adequate administrative remedies available, and therefore the plaintiff should go pursue them. That flips on its head the administrative process that occurs in this Commonwealth that is very carefully crafted, and for good reason. Because what the trial court judge had to do here was decide if all of the asbestos was out of the boiler house. We had to sit there and try and prove a negative, which was impossible. Further, the trial court had to consider, are the RCRA metals out? Is there mercury? What's on the soil? These are very technical questions that have been entrusted to the DEP and the Allegheny County Health Department because they are the entities with the expertise to deal with them.
Counsel, can I go back one more time to a question that Justice McCaffrey asked a very long time ago? Did your client submit a remediation and abatement plan? I'm assuming this had to be to Allegheny County based upon what you're talking about, for any toxin other than asbestos?
So the permitting process through the Allegheny County Health Department deals with asbestos.
Okay.
However,
that's been your opposing counsel's point all along. That's what they deal with. That was not the entirety or the essence of the concerns of the plaintiffs here.
Your Honor, that argument misses the mark because it confuses the asbestos abatement permitting process with the other authority that the Allegheny County Health Department has. Of course, it imposed several conditions on the blast. In this case, those conditions are part of this permit. So among them...
Okay, before you go there,
Sure.
Did your client submit an abatement plan to the Allegheny County Department of Health for any other toxin than asbestos?
Your Honor, a plan did not have to be submitted to the health department for anything other than asbestos, but there are DEP regulations that mandate the removal of other things, and all of those regulations were complied with. And again, those would be DEP regulations that if they had issues with how things were conducted, that again would be within the purview of the EHB.
And was that, everything that you just mentioned now, was that part of the application for the permit process? That all of those things had to be considered before the permit was issued?
I'm not sure of the answer to that question, Your Honor. I can tell you that the site owner had the obligation to be in compliance with all regulations. Among them was removal of things like mercury and the sort.
So somebody just takes their word for it? Or do they have to have something when they apply for a permit that says they have taken care of and considered all of the other toxins involved?
For the blasting permit, Your Honor,
that's the only permit we're talking about here, right?
right. I'm not sure of that, but what I can tell you is that the Allegheny County Health Department was absolutely concerned about dust being admitted from the implosion. We are not minimizing what happened on June 2nd with the chimney implosion. As counsel said, there are at least seven cases filed in the Allegheny County Court of Common Pleas. Those are all relating to property damage and injury arising out of them. We are not contending those belong before the EHB. We are contending this case does.
But you are contending, I'm sorry to interrupt, but just to wrap up this point, if I can, you are contending that the train had left the state. Once the permit was properly granted according to EHB procedures, there was no authority, no substantive authority in the EHB or DEP to address any nuisance claims, right? That train had left the station in your view, right?
I disagree, Your Honor.
Okay, tell me what remedies survived that in terms of nuisance claims.
let me make sure I understand your question. So I don't think, from what I understand from Mr. Kane today, they are not contending that there was not an adequate remedy before the EHB. I believe they conceded that there was. They're simply contending that toxic dust, there's no adequate remedy there. The point is the Allegheny County Health Department is the entity that properly regulates dust in Pennsylvania. That's what they do by statute, and that's what they did in this very permit. And so if the plaintiffs had pursued administrative remedies before the EHB, you know, I think what the EHB would have done is said, as far as dust goes, we defer to the health department on this. And so go pursue your administrative remedies before the health department. The argument that they didn't have enough time to do it is simply without merit.
How would the EHB have issued a supersedious in that circumstance where they're saying, we don't have any jurisdiction over that, go somewhere else?
They have
and 2 days later, the blast is going to take place.
They have jurisdiction to enjoin the implosion. And because the DEP is charged, you know, with being a trustee, you know, for the Commonwealth over public health and safety, they put it in this permit. The DEP was clearly concerned about air quality because they conditioned the issuance of their permit on the health department taking a look at this. And so I'd like to actually mention the conditions because, again, these are things we don't want a trial court judge sitting in equity considering. First, demolition may not take place during periods of wind speed over 25 miles an hour. That's a very technical scientific finding. We don't want plaintiffs coming into court, as valid as their concerns may be, saying, I'm afraid that's not low enough. And we don't want a trial court judge sitting in equity second guessing whether that's adequate.
That's not what happened here. That's not what happened here. This wasn't a de minimis concern. Not that the airspeed is necessarily de minimis, but in the big scheme of things that we're talking about here, that's not what the concern was here. This was a much broader concern.
We do not minimize the concern at all. I believe the concern is valid. That, Your Honor, is why it should have been brought in front of the proper forum that has the proper expertise to handle it.
Counsel, let me see if I understand though. Anybody who represents a regulated entity is reluctant to concede that EHB can do anything, right?
I was afraid you'd go there.
Your client is the permit holder. In front of the EHB, when someone challenges a permit, usually the permit holder and DEP sit together on one side of the room to defend the issuance of the permit. That's usually how it happens, right? I guess my question is, you're going to have to concede something, I think, if you want to win this case. You're going to have to concede that if the plaintiffs had brought in all of their concerns about these environmental factors and claimed that the Allegheny Health permit was not adequate, that Allegheny Health hasn't considered these issues, that the EHB needs to consider these issues de novo, that EHB could then, based on their concerns about if this blasting goes forward, X, Y, and Z is going to happen, you need to look at this permit again closer, you need to look at Allegheny County's permit because you made it a condition of the issuance of the DEP permit, and you need to address their concerns, and maybe you put additional conditions on the permit, and maybe you say the permit goes away. Don't you have to concede that the EHB can do all of those things in its broad authority in reviewing a DEP permit?
I completely agree with you, Your Honor. And to that point, though, say if it didn't, I think it is very clear here that the plaintiffs had an adequate administrative remedy. They could have filed before the EHB. They had the time to do it. They had the notice. They were in court the exact same day. They could have electronically filed in the EHB. Why they didn't, I don't know, but they didn't. And that decision has consequences. But one, just to exercise, for related to your question, Justice Bronson.
Before you go on, if it were that clear, we probably wouldn't have taken the case to consider.
Fair, Your Honor, and I guess on that point is that there's also authority that where there is a clear administrative remedy, and perhaps there are other issues that could be in an area that's more gray, the administrative remedies should still proceed first, so that we're not left here, as we are, questioning what remains. So the administrative remedies proceed first, so that there's a full record with the right parties. The DEP would have been a party before the EHB. That would have really helped the trial court here. So that avenue is available. That proceeds first through the EHB. And then if there's anything left over, then you proceed to the trial court. The plaintiffs are not without a remedy here. They have several. It just needs to proceed in an orderly fashion. Otherwise, we have the procedural morass that was created by the trial court here.
All right. Are there any other questions for Ms. Veit? Thank you. We understand your arguments, and they were very well done. Thank both of you for that.
Thank you, Your Honors.
Should call the next case. Mr. Minner?
Commonwealth of Pennsylvania versus Andre Johnson, representing Mr. Johnson, Mr. Jordan Taylor, representing the Commonwealth, Ms. Margaret Ivey.
And away we go.
Morning, Ms. Ivory. Is Mr. Taylor in the house? In this case, there is some coarse language critical to the legal issues which we're going to look at today, and I will abbreviate for purposes of this oral argument some of that language. In 2021, Officer Tabitha Wolf initiated a traffic stop of appellant's vehicle. After issuing appellant 2 citations, the officer advised appellant she was going to impound his vehicle pursuant to department policy. At this point, appellant became angry and demanded to speak with the officer's supervisor. When told there was no one else he could speak to, he called Officer Wolf an effin' B several times and told her she was no woman. He also remarked that he would be seeing the officer's daughter, but that she had no reason to worry because he was a lover, not a fighter. A tow truck driver who was on the scene reported hearing appellant say that he wanted to F the officer's daughter and get her pregnant so that he could cost the officer money like she was costing him money by impounding his vehicle. Based on these statements, appellant was charged and convicted with disorderly conduct, which provides that a person is guilty if, with the intention to cause public inconvenience, annoyance, or alarm, he uses obscene language or makes an obscene gesture. We granted review in this case to determine whether the definition of obscene in the disorderly conduct statute requires an appeal to the prurient interest, and if so, whether appellant's language was indeed obscene. Please proceed.
Good morning.
Morning.
Madam Chief Justice, may it please the court, counsel. My name is Jordan Taylor. I am here on behalf of Mr. Andre Johnson. Mr. Johnson was convicted via the disorderly conduct statute under A3. While the disorderly conduct statute is principally geared at maintaining public order, the A3 subsection necessarily considers the content of the regulated speech. The United States Supreme Court has already delivered for us Miller v. California, which in '73 has been our guideline for obscenity ever since. the guideline from Miller in California is derived principally from Roth. In this particular instance, we do not have a in-section definition for obscenity. We point to, excuse me, I believe it's 5903. 5503? 5503, yes, thank you. Which,
Are you referring to the disorderly conduct statute or the obscene and sexual materials?
obscene and other sexual materials and performances.
They put that, I noticed that, of course, in your briefing, counsel. They put that in a different section.
Yes.
And so I wonder if we should consider that maybe they didn't mean for that definition of obscenity to apply in disorderly conduct. And in that regard, do you believe, first, what's the basis for us importing that section's definition here? And secondly, do you think that our General Assembly can constitutionally penalize statements as obscene outside of the Miller standard? In other words, comments like this, which, don't meet what Chief Justice Berger was talking about with this prurient interest, which is kind of odd language, but there it is. That seems to me at the heart of this case. Would you comment on that?
Yes, Justice West. To answer the second question first, I do not believe that the General Assembly is permitted to regulate or criminalize the content of speech outside the Miller standard, at least for obscenity specifically. If the General Assembly had wanted to just contain tumult from someone's public statements, subsection A1 would have been perfectly sufficient.
Well, when you look at 5503A3 and we're looking at obscene, that section does not require an appeal to prurient interest. And when you look at the comment to 5503, it says under subsection A2 and 3, the offense is extended to coarse or indecent utterances and abusive language, which are understood to be milder and less offensive than obscene ones, thus subtracting that prurient interest requirement. Could you comment on that?
Yes, Madam Chief Justice. The language from the comment predates the U.S. Supreme Court standard in Miller. Part of the issue is that the formulation of the language is from Roth and is
from what?
Roth, excuse me, and is absolutely broader. I would point to.
If coarseness was the standard, a whole bunch of speech could be criminalized.
I would not be here today,
Most of the
unfortunately.
social media world wouldn't exist.
Yes. I would point to section 2709, which is our harassment section. At A4, the phrasing it uses is lewd, lascivious, threatening, or obscene words, language, drawing, or caricatures. Our state's case law recognizes that terms such as lewd and lascivious are broader than obscene, in part because they cover actions as well as speech. So, for example, in our public indecency statutes, oftentimes lewd is the term that the courts have used to describe the conduct at issue. That doesn't need to be sexual or appeal to the prurient interest. As this court has said, nudity is not in and of itself obscene. But
go ahead.
Oh, no,
please finish.
Okay. But behavior such as nudity can be regulated separately and with a different
Right,
standard.
and let's focus on language here.
Yes.
Well, you can finish your explanation if you want with respect to language rather than getting into the other kinds of lewdness.
Thank you. When it comes to speech specifically, I believe it was the Superior Court in Stoke put it better than I would have, which is that when it comes to regulating speech, the confines must be narrowly circumscribed. And while obscenity is recognized as one of the exceptions to our First Amendment, that is a narrow category quite intentionally.
And it's almost never prosecuted anymore, in the adult context.
I would have to defer to your
I mean,
expertise
since
on that.
the days of Roth and Jacobellis, you don't see those cases anymore. You just don't see them. Isn't that right?
Yeah, they seem quite uncommon, at least in my personal experience.
In the context that this speech occurred, an officer, a police officer, stopping or arresting an individual, I was surprised that there wasn't that the Commonwealth didn't charge some sort of threat, didn't charge him under the threat statute. Was there initially, were there additional charges, or was it just this one?
I believe it was just this one.
She could have charged A1 or even A4. I mean, it's just a charging mistake by the officer, isn't it? Isn't that what this is?
I mean, quite possibly. I wouldn't comment on whether or not, Mr. Johnson could potentially face liability under A1 or A4, but it is a bizarre choice. It seems, in my mind, that the officer has employed the colloquial understanding of obscenity, which is closer to something merely being coarse. And while we may understand that to be objectionable, vulgar language, that doesn't necessarily mean it's criminalizable. Yes. Any other questions?
No?
Anything else you'd like to
No.
tell us? All right, thank you very much.
Thank
Let's
you.
hear from the Commonwealth, Ms. Ivory, and particularly I'd like to know why you didn't charge A1 or A4, but you can go ahead with your argument.
Okay, may it please the court, my name is Margaret Ivory. I'm an assistant district attorney in Allegheny County. I'm representing the Commonwealth. Well, the key point I would make before I get into anything else is that in this court's words, in terms of the disorderly conduct statute, the overriding or cardinal feature is actually public unruliness that can lead to tumult and disorder.
That's A1, that's not A3. I mean, this is, what's the appeal to the prurient interest? I mean, there's no, if there's a threat, you don't charge A3. What, you're talking about tumult, that's A1, isn't it?
And
I believe
a threat,
it's,
which is, yeah.
excuse
Well,
me.
true threats is another category of
Yep.
exception to
I
speech.
believe I believe the language I'm using pertains to the statute itself, that's the cardinal feature of the offense of disorderly conduct. And that whether the words or acts, generally speaking, is according to Hawk, the Hawk
So
case.
you're relying on A before we get to the subparts, and A says offense defined, a person is guilty of disorderly conduct if with intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, and then we get into the subparts, but he has to do something that fits into a subpart.
Well, yeah, and that's the whole nub of the case.
Well, you have,
That's a nub, Justice
This
Bronson.
is the Brobsonian,
Yes.
Anyway.
I apologize.
That's all right.
Me too, I apologize. It took us until the second day to get to the nub of the, this is an inside joke.
So sorry, but if you could just address the subparts and why perhaps it maybe he was charged under the wrong subpart. And if you think that this falls within the definition of obscene and that the qualification of the requirement of prurient does not apply here, enlighten us to that too. Speak up.
Okay, initially, I would respond that there are many cases in these types of situations where somebody could be charged under different sections or with different offenses. I think if you're looking at in terms of the prurient interest requirement, then you could arguably say, oh, well, he made a threat, but then of course there is, or it would have been better construed as a threat, or at least that's what the dissenting opinion in Superior Court said. Is it a legitimate threat? Is it a serious threat? As I was saying,
But in order to sustain this charge, you're going to have to persuade us that it fits within A3.
correct, it has to be obscene language.
Right.
And I would submit that the prurient interest requirement was engrafted from another statute inappropriately
Never
without any
intended to be in the disorderly conduct
isn't
statute.
that the problem?
That's-
Is it like we have a paradigmatic clash here because you're, and again, I can't really fault the officer or even your office, because you have this obscenity language, but it's out there for like what's still surviving from the obscenity jurisprudence after Miller, with respect to like pornography. So to the extent that still survives, it really doesn't really much. But then you engraft it over here in the disorderly conduct context, and it doesn't fit, does it? Because there's no like sort of there's no pornographic. It's not a.
It's offensive. It's not.
It's offensive conduct, but you can't criminalize it on obscenity grounds because that's this prurient interest.
Unless obscenity in the disorderly conduct statute means something different than it does later when it's.
And if it
Maybe
does, how does
counsel-
it comply with the first?
Maybe counsel has an answer for
go
that.
ahead.
Maybe counsel has an answer for that. What
Yeah.
makes this language obscene?
What makes this language obscene in this case? That's more the second issue, but I believe it falls under all. I looked at it in terms of three categories. If you're looking at, again, I'm focusing on the fact that it was in the course of public unruliness that can lead to tumult and disorder.
But it still has to be obscene. What makes the words used here singularly and cumulatively obscene?
Okay, well, they were coarse. Going with the least harsh standard, they were coarse, they were rude, they were indecent, and I can't remember the third requirement. But
Okay, and is it constitutional to control that type of speech, coarse speech?
if it's in the course of public unruliness that can lead to tumult and disorder, that's a different matter. However, I would also move on to the fact that just under common parlance or common understanding, again, I'm citing, I guess, the dissenting opinion in the Hawk case in terms of similar language that was used to this case, leaving out the specific comments about the daughter, that it would fall within the common understanding of obscenity. The F word, the B word, the entire context of it, the way it was, all the things he said to her. And then I would go to the fact that if anything is going to appeal to the prurient interest, he certainly did. And that's why this is one of the few cases that actually was affirmed.
The jurisprudence, it almost sounds quaint at this point, 50 years on. But the whole body of jurisprudence under Miller and Roth and Jacobellis and these Burger Court era cases, right? When I know it when I see it's Potter Stewart, right? It was all this stuff about exciting lustful thoughts, right? And that sort of thing. And there's that prurient interest. This case has nothing to do with that, does it?
No, none of them
right,
do.
it's the coarseness, it's the rudeness,
Disrespect.
but the disrespect. I mean, so that stuff cannot be criminalized under our First Amendment, can it? As disgusting as it is.
Well, according to Shaplinski, it can't. I mean, obscene speech.
Well,
is
that's
not,
fighting words, but that's fighting words, and that's within A1 or under harassment. But that's not A3. You can't say that Shaplinski's A3, can you?
My understanding of it was that obscene speech, it denotes that obscene speech is not protected when it discusses the levels of protection that...
Are you saying this is a fighting words case?
No, I'm saying it's obscene. It's an obscenity.
Well, that's not Shaplinski.
Are you saying that it is akin to fighting words? I mean, you keep trying to tie this into the introduction to the exceptions. Is your argument that these words are akin to fighting words and we could criminalize them for that reason?
To the extent that they can just as equally and are just as capable of causing public inconvenience, annoyance, and alarm. You know, to the extent, you know, yes, because if the actor is demonstrating public unruliness, then can lead to tumult and disorder. If their words or actions rise to the level of disorderly conduct hinges upon whether they cause or unjustifiably risk it. That, of course, leaves it somewhat open to other factors.
So if the general predicates are met, the lead into the exceptions, then coarse language is the basis for a prosecution.
I've never seen coarse language be, but according to the comment, that's.
This is. Yeah,
I'm
denying that it appeals to the prurient interest. You've described it on a number of occasions as coarse language.
Unless there's some other definition of obscene here.
That's what I asked you.
Well, it's beyond. This is far beyond coarse language. I'm not
so what
advocating for the coarse language definition.
Okay, so how do you describe it? I asked you that question earlier. What would your definition of obscene be that would encompass the words or the cumulative nature of the words in this case?
In this case, I would go back to what the common understanding of it, the best you can understand from the Hawk dissent, that it's obscene language, the F word, the B word, those types of words under the common parlance are obscene. That being said, those alone do not make one mean that somebody's committing the offense of disorderly conduct. It's then you get into the other circumstances, whether there was an intent or they recklessly risked a public disturbance.
Let me ask you something, counsel. In the contemporary society, which we're currently all members, are the words that were used here in the common understanding words that are in fact obscene? Given the regularity with which they are used and the persons who regularly use these words, I mean, are these words in our common understanding obscene words?
Might have to depend on which one of us you ask, but go ahead.
I'm asking her.
Well, I would submit that if they're not, then there aren't very many that are. They're
Maybe yes, maybe no.
They are.
Well, counsel, didn't this ship sail 57 years ago or so at Cohen versus California, when Mr. Cohen walked through the halls of the LA courthouse with the shirt that said F the draft? It didn't say F, it spelled out the F word, right? And he was prosecuted. And SCOTUS tossed that case. And the majority, in the majority opinion, pretty much went through in a succinct way. It was Harlan. It was sort of, I mean, I'm really grateful that you folks brought this case because it's fun and we don't get these cases. They all go to federal court. So thank you both. But this is, seems to me, just a charging mistake, because don't you agree that if it's not, and if this is upheld, your office is going to be extremely busy with all the F-word cases that could be brought every minute of every day here and anywhere else in Pennsylvania.
But you have context in this case, too. It's not just someone walking down the street using the F word. It's in the context of a female officer trying to effectuate an arrest.
Yeah, there's always a context. I'll grant you that. There's always a context.
Of course, and that's where there has to be a burden to actually articulate facts as to why this was actually public unruliness that could
But don't we also have to define what the word obscene means? I mean, you're essentially
I thought you were going to define the F word.
I mean, you're essentially saying, well, we know it when we see it. And I didn't think we could do that anymore.
Well, that's I'm just going with the language of the statute. Is that it's somewhat ambiguous. Some definition would be welcome, because obviously these cases.
Let me have one more try then. Let me ask you. Let's say that you win this case. Okay. You're the DA's office, so all these police agencies throughout Allegheny County are going to be very interested in getting guidance from you going forward on how to enforce and apply A3. What what would you recommend would be, if police chief comes to you after this case, and let's say you win it, what would your guidance be to that chief on application of A3 for his or her officers?
I guess, again, I think it goes down to the public unruliness, and I think they are well-versed in those situations.
Well, if the chief says to you, okay, Ms. Ivory, I understand public unruliness, and that's A1, and sometimes it's A4, but what do my officers do with respect to A3? What's the standard, what's the rule of the road for officers in my department?
I think it's like a reasonable suspicion type, or it's circumstance dependent. I can't.
Well, isn't that highly idiosyncratic up to the officers' sensibilities?
Well, they do have to oftentimes respond that way, or else other things, can go wrong.
Well, they do a lot of street-level adjudication, but they ostensibly know what the law is. And what would the law be, in your judgment then, by way of your instruction to them or guidance to them on A3?
They have to be cognizant of the circumstances, who, if anybody was actually inconvenienced, if there was actually a risk of harm to anyone, or annoyance, alarm, et cetera.
Would this same charge have been brought, or would the same charge be applicable if the words were directed towards someone other than a police officer or a governmental official?
It would be applicable.
I'm asking a different question. I mean, under those circumstances, what would an officer do? How would they judge the words?
They would have to get the information from the witnesses. I mean, that's the, you have the, that's, if no one's, anything, any obscenity can be, if it's said in a vacuum, if nobody heard it, if it didn't have any, potential for.
Counsel, if I may.
Yes.
With regard to the context of this particular comment, share with us where it appeals to a prurient interest.
Okay, so the context of this particular comment, I would submit that the language used in terms of the officer's daughter was graphic, that it fits within, that it tends to appeal, the definition of pruriency, which is the tendency to excite lustful thoughts, roughly encompassing a shameful or morbid interest in, among other things, sex. So I would say it's a, encompassing a shameful interest in it.
So
as
he
much
was
as
trying to excite, and then to follow up on Justice Doherty's question, are you saying that Johnson was trying to excite lustful thoughts within the meaning of Miller, in himself or the officer? What's the argument there?
I don't think you can. I don't think that's why Miller isn't applicable. I think, but to the extent that that applies, this case would, you can, in the terms of, there's more of a tendency to disgust and offend and
Well, that's
threaten.
not Miller. I mean, that's not what SCOTUS said is prosecutable in obscenity. So you are saying, I guess, that you think our General Assembly could criminalize some other species of obscenity, even though SCOTUS has apparently said there's only this space left.
I'm just saying that, with all due respect, what I'm saying is that the obscene materials and performances do not apply to a public confrontation, public unruliness within the context of disorderly conduct.
So you wouldn't suggest that we adopt the statutory definition of obscenity and plug it into this?
That's really your best argument. The 5903 doesn't apply.
Correct. That is my argument, that it does not apply, and that by adopting the prurient interest then leaves open a vast category of obscene language that can rise to the level, or that can lead to tumult and disorder.
See, but
because it's not prurient.
I keep getting back to the question. Let's say we were writing an opinion and we wanted to do what you're telling us to do. How would we define obscene?
Well, I think that's
so
up
that
to
the
you.
public knows what they can and cannot do, and so police officers know what they can and cannot charge.
And if it's an alternate definition than that offered in 5903, we'd like to hear what your alternate definition would be.
I don't have a concise definition of it. My position is that the prurient interest one is completely inapplicable. It misses the mark and misses the point of the statute.
When you look at 5903, it's a conjunctive rather than a disjunctive paragraph. If it said or, maybe the definition wouldn't be so difficult to apply in your context, but it says and I mean, it seems to really nail down the prurient interest requirement. All right. Any other questions for Ms. Ivory? Thank you both very much. Interesting case.
Yeah, very.
County of Allegheny versus Allegheny County Prison Employees Independent Union, representing the union, Mr. Eric Stoltenberg, Fulton County, Mr. Diego Pereira.
We do.
In this discretionary appeal involving a labor dispute, the union filed a grievance contesting disciplinary action the county took against an employee. Throughout the grievance procedure, both parties failed to adhere to the time constraints agreed upon in their collective bargaining agreement, including where the union moved the grievance to arbitration. When the union moved the grievance to arbitration. On the date of the arbitration hearing, for the first time, the county raised an objection to the timeliness of the grievance. The arbitrator found that the county waived its objection by failing to raise it prior to the hearing and by itself neglecting to adhere to the collective bargaining agreement's time limits throughout the grievance procedure. After the arbitrator resolved the merits of the grievance in favor of the union, the county appealed to the trial court, which vacated the arbitrator's award. The Commonwealth Court subsequently affirmed the trial court's order vacating the arbitration award, and this court accepted review to consider whether it was within the jurisdiction of the arbitrator to resolve the timeliness issue and whether her decision on that issue met the deferential standard of essence test review. Please proceed.
Good morning. May it please the court, Eric Stoltenberg for the appellant in this matter, the Allegheny County Prison Employees Independent Union. The first question that the court granted appeal on here is whether the contractual or a contractual time limit on a union's right to appeal grievances to arbitration precludes the grievance arbitrator from holding that the employer waived its timeliness objection by failing to raise that until the day of the arbitration hearing. When we looked at this, the question as it was posed by the court, it seems to strike to the heart of subject matter jurisdiction. In other words, is the timeliness of a grievance arbitration notice to an employer a question of subject matter jurisdiction that may be raised even by the court sua sponte? And when we look back at the case law that has been decided by this Supreme Court and by our other appellate courts, the answer is it depends. The question is, when it comes to subject matter jurisdiction, is whether or not the time limits are statutory or they are contractual. So when the court identified the issue in this case as being a contractual time limit on the right to appeal to arbitration, that's very significant because those two things are different. This court decided a case not very long ago, just a few weeks ago, interest of GGB. It was a child custody case where it discussed at length subject matter jurisdiction. And it defines subject matter jurisdiction. Whether a court has subject matter jurisdiction inquires into the competency of the court to determine controversies of the general class to which the case presented for consideration belongs. The pertinent consideration is whether the court could enter upon the inquiry, not whether it might ultimately decide it was unable to grant the relief sought in a particular case. And it was very clear, you were very clear that subject matter jurisdiction is distinct from the court's power to act in a specific matter. Claims relating to a tribunal's power are, unlike claims of subject matter jurisdiction, waivable. So what's the power or the authority in our case? It's the power to interpret the CBA, and we believe that's vested in the arbitrator. Subject matter jurisdiction is conferred by the Commonwealth's Constitution and laws. That's what interest of GGB said. A timeliness challenge can be a question of subject matter jurisdiction, again, where it flows from statute. So the time limits for filing, for example, the time limits for filing an appeal, let's say from a decision of a lower court, we have only 30 days to file a notice of appeal to move a case through the appellate courts.
Is your opposing counsel arguing that this is a subject matter jurisdiction case?
I'm saying that the issue, I don't think they are. I think they're saying it's.
Why are you talking about that?
I think it's an important distinction because
I think everyone would agree with that. If this were a violation of a statutory time limit, then we would have a different issue before us.
Well, statutory time limits can apply in arbitration cases.
I understand that, but the first question talks about a contractual time limit.
Right.
And implicates the arbitrator's interpretation of it.
And contractual time limits by our standing case law are waivable.
Okay, right.
As opposed to statutory ones.
Right.
So what we're saying is that is an issue, that is a power or an authority that a grievance arbitrator has, whether we're talking about under Act 111 or we're talking about under Act 195. So, in terms of the initial case, that time to answer that specific question, and I guess that's why I was getting into that, explaining the difference, is that the grievance arbitrator has that authority.
Right. And the Commonwealth Court disagreed with the arbitrator's interpretation of the contract.
I take the Commonwealth Court's decision as being that once the time limit is violated, that ends the arbitrator's jurisdiction. That's why I felt like subject matter jurisdiction was worthy of some discussion, because it seemed to me that's exactly what they decided. Because if we accept the fact that that contractual time limits or contractual obligations are things that can be waived, then the arbitrator was fully within her authority to make that determination.
Well, except when there's two ideas of waiver here. One is the waiver argument that because you waived the time limits for them to issue decisions and things like that, that means they had to waive your failure to do a timely appeal.
Right.
So your grant of grace means they necessarily had to give you grace in return. That's the one waiver argument. The second waiver argument is once you filed your arguably untimely demand for arbitration at the final level, they had to do something within so many days, hours, minutes to raise the untimeliness issue and not wait until they filed their pre-arbitration memo with the panel, right?
Right.
Okay. So let's take the first one, because I agree with you in principle that the arbitrator could interpret an agreement to provide a consequence for waiver or for silence, or even if imposing grace, if you give them grace, they have to give you grace. How do you deal with the language in the CBA, though, that specifically says what happens if a timeline is not followed?
Well, I'm not hanging my hat on the first one, that we gave them grace and they have to give us grace. We let that go.
You're abandoning that?
Yes, it's not the focus of this appeal.
Okay, so we're only talking about once you filed, they had to raise the lack of doing the arbitration request within a certain number of days. How many days did they have to do it? How many hours? That's
for the court, I think, to decide, or for the arbitrator to initially decide. So I think here's a good way of looking at it. Once we made our demand for arbitration, we were 5 days late. After we made the demand for arbitration, there's a number of things that have to take place. We have to get an arbitrator. And the way that we get that is I have to contact the county and say, I don't have any suggestions, or maybe I do have a suggestion for an arbitrator to hear the case. In this case, I said, I don't have any suggestions. Let me know if you do. If I don't hear from you in a week, I'll write to the Bureau of Mediation per the contract, and I'll request a list of arbitrators. So we did that. Got a list of arbitrators. The list is delivered to me. The list is delivered to the county. We then have to go through the process of striking from the list. There's an opportunity there at any time to say, listen, your grievance was untimely. That never happened. So we get the arbitrator. We then have to contact the arbitrator, have discussions with the arbitrator about having a hearing. When is the hearing going to be? We go through the process also of determining, are there any documents that need subpoenaed? We'll get subpoenas for documents. We might get subpoenas for witnesses. There's a lot of things that can take place. If this had been, let's say, a fitness for duty case, where we have to get medical experts involved to determine if my client is fit for duty, maybe psychologically or medically, we might go take depositions. So let's assume that we went through all of that process. All along, my client is paying me to do that work. And potentially we're paying an expert to give us an expert report, to give us a deposition. Maybe we then take the deposition of the county's expert. And we appear at arbitration months and months and months later. In this case, 6.5 months later, thinking, okay, well, there's no timeliness issue at this point. We've taken all these steps. We've gone through all this time, subpoenas, depositions, et cetera. And now the employer says for the first time, by the way, you were 5 days late. So
I appreciate what you're saying. I'm trying to understand. Let me unpack what you just said so I make sure I understand factually and what your legal argument is. To assert a waiver argument or an untimeliness argument, you at least need to know who the arbitrators are, because you have to, it's not giving you notice that they're going to raise the defense. It's putting it in front of the arbitrator at the earliest possible time. Do you agree with that?
Yes, or at least notifying me as the
well, but that doesn't do anything other than, I mean, in terms of perfecting the proceeding in the trial court, the idea of waiver is you have to present it to the adjudicator at the earliest possible time.
Waiver, yes, absolutely.
Okay,
sure.
so what was the earliest possible time, in your view of that litany, that they had to present this issue to the arbitrator? Would have to have been after the arbitrator was selected.
Correct.
So was there a time in that process you just said where you were communicating with the arbitrator where they could have said, hey, before we get too far down the road here, there's a timeliness problem that you need to decide?
That could have happened when we selected the date for hearing.
Okay.
However, I think the waiver argument is mine. I'm the one that has to, as the union in this case, I have to raise the argument, hey, you've waived it because you didn't raise it. So I think there's a step before we get to waiver, which is the county, the employer.
Well, that's what I mean. Sorry, I may have said waiver. When in that process would they have had the first opportunity to raise in front of the arbitrator the timeliness issue?
In front of the arbitrator, it could have been any time through a phone call, an email, anytime.
So anytime after the arbitrator was selected, who you knew who it was, your point is, once you knew who the arbitrator was, they should have hit an email right away to the arbitrator copying you saying, wait, before we get too far down the road, before any of us expend money, before we hire experts,
yes,
there is a timeliness issue that we want you to decide right now. And because they didn't do that, because they waited, waiver.
Correct.
Okay, thank you.
And I'm saying also that even before the arbitrator was selected, it could have been when they received the notice from the president of the union, hey, we're taking this matter to arbitration, and they look and say, hey, we think you're late. Tell me then. At least at that point, as the union, I've got some decisions to make. If I know early on, I might say, geez, it is late. Maybe we ought to just consider abandoning this grievance. I might have made that decision. I might have asked for bifurcation, to ask the arbitrator, hey, maybe there's some issues here. Let's split this matter in two. Let's address the procedural issue first. What if this case, in terms of the procedural objection, the timeliness objection, involved calling witnesses to testify about when something was received or how something was communicated through email, some computer issue? They might have come to the arbitration hearing with 3 or 4 witnesses, and I have none, because I have no notice that they're even going to raise a procedural issue, and then how do I deal with that?
But isn't this case really about more than the timing of an objection? Isn't it more about the power of the arbitrator?
Sure.
I mean, isn't that really what we're here to look at?
I think it is. Here, sometimes a way to really open up a case is to look at what it might have been. Let's assume, just for the sake of argument, that in this case, We make our appeal, it's 5 days late. The county immediately says, hey man, you were late. This case shouldn't even go to arbitration. The arbitrator's not even going to have jurisdiction. And the union says, well, that's fine, but we just think that that's sort of advisory language. We don't think it really applies. And let's assume for the sake of argument that it's very definitive, that you have to perfect your appeal within a certain amount of time, or that's it. And we get to arbitration, and the arbitrator says, yeah, well, I agree with the union. It's really sort of advisory. I don't think you really have to appeal, follow those time limits too closely. Well, that's a problem under the essence test, because now, you're not, that language can't be, the arbitrator's decision doesn't really jive with a rational interpretation of the contract language.
That's not this.
That's my point. Because in this case, what waiver is to us is a party obviously has a right under a contract to assert something, whether we're talking about a construction contract in a multi-million-dollar case or this little labor case here over a 5-day suspension. You have a right to raise a particular argument. And when you don't, through your action or your inaction, you're waiving that, you're giving it up. So they had a right under the contract. I'm not asking you to pretend that the contract language doesn't exist or that time limit is sort of meaningless. I'm saying that when they choose not to say anything until the day of the arbitration hearing, putting us at great time and expense for 6.5 months getting this case ready, or at least getting, spending time on it and billing the client for it, they have they're responsible for that. And the arbitrator then has the authority to say, pursuant to this court's long ago decision in School District of Duquesne and the Commonwealth court case and Turnpike Commission that followed it, that they have the authority to apply regular contract principles and use that to decide the case.
Well, but that's not really a contract principle. That's a procedurally, the idea that the arbitrator would do all the arbitrator's prep, the parties would do all their prep to have the merits hearing. The idea that the arbitrator would say, once the timely issue was say, you guys didn't raise that to me soon enough. You're out. That's a procedural ruling more than it's a contract ruling, isn't it? Isn't that saying you've waived it procedurally, not under the terms of the contract? You've waived it procedurally, and I, as the arbitrator, have a great deal of power over procedurally how I handle this proceeding.
That's fair.
Isn't that exactly what the arbitrator was doing here?
Yes, but I guess I look at waiver and estoppel as being anything.
Can I go back a step, because
Sure.
I'm a little bit surprised that you've essentially abandoned with a lot of what the arbitrator based the thought process on anyway, which is this grievance has been going on forever, and there's never been a moment when anyone has looked at the timeliness of any of the steps that were set forth in the contracts. Therefore, since timeliness was never of the essence to either party in this case, I am not going to do it at this juncture. Why are you giving up that argument?
Well, I mean, it was certainly fair, and that was within the arbitrator's decision. She certainly has the authority.
That goes to her interpretation of the contract.
It does. It does. I just feel that
With which the Commonwealth Court disagreed. The Commonwealth Court essentially said, that's not how this contract works. We're going to tell you what this contract said and how it has to be interpreted.
Well,
which would be problematic, correct?
Let me say
up to the arbitrator?
Let me say this, and I hope this answers your question. When we did not object to them being untimely, we essentially waived that.
So you agree with the Commonwealth Court?
Only
because that's exactly what the Commonwealth
in terms of that, sure. But that's why, to me, the far more important part of this case is the fact that we were ready to take this case to arbitration on its merits, and did, and then we got no.
How do you justify your waiver when the CBA said that any mutual waivers must be done in writing?
Well, it does say that. However, we had no notice that this was even going to be an issue. So what we're saying to you is that that's sort of where you get the subject matter jurisdiction, I think. Because to me, when I look at the Commonwealth Court's decision, they say, sorry, we interpret the contract as being black and white, And so when you don't meet when you were 5 days late, this case is over. That works for us, like if there's a statutory issue. But it doesn't necessarily work when it's a contractual time limit, because when there's a contractual time limit, all of the regular theories, whether you look at waiver and estoppel as being a contractual principle, those things are within the arbitrator's quiver. She can reach into that and pull it out and use it.
Okay, but that's why I'm confused about this notion that you're giving up the analysis of the arbitrator of the contract. She analyzed the contract and said, I'm looking at this contract, and yeah, I see all of these, time constraints on when action has to be taken, but nobody in this entire proceeding ever stood by any of these time constraints, and so I am not going to do it here. You're standing here saying she was wrong? I mean, but that's her purview, isn't it?
I'm not saying...
That's my question. Suppose she was dead wrong in her interpretation of this contract. Doesn't she have the authority to be dead wrong under the essence test?
Maybe not. Well, and that's why I was using an alternate example. That's why I'm saying that, remember, we analyzed that decision-making, that deference to determine, are we sort of making a mockery of what's in the contract language? Is it rational to interpret it this way? If her interpretation was simply, well, if one party doesn't do it, then the heck with it, that might be a problem for me as the union in this case, especially if they've raised their time limits issue timely, and I didn't. But in this case, that didn't happen. And when that didn't, that's why, to me, the second part of the case, when you're asking, did I sort of abandon that? I guess I sort of did, because I don't see it as important.
The problem with the timeliness analysis, and you're being candid, Mr. Stoltenberg. I think that's good. Recommend to any future lawyers that they be candid as well. The problem is all of the waivers that the arbitrator identified had no consequence to the county, the city, because the contract specifically provided what happened if they didn't do something in time, and it was reverted to the prior agreement, which you didn't want.
Right.
You wanted a decision from them, and so their lack of timeliness inured to your benefit because you actually got a decision at that level as opposed to reverting to the last one, which didn't benefit you.
True.
Right.
Well, and back to my question a while ago, we didn't take the case to examine timeliness and waiver. We took the case to address the power of an arbitrator and the essence test.
Right. Well, and I think under the essence test, as long as the arbitrator, we have to accept that the arbitrator has the authority to apply things like waiver and estoppel. Mm-hmm. I mean, I think the case law is pretty solid on that. And when we accept that, we have to look at the facts of the case. I really believe it's going to be a fact-specific analysis. And when you look at grievance arbitration decisions, when the appeals of those under Act 195 are analyzed, we are looking at the facts to determine if, based on the facts of the case, can this rationally be derived from the CBA? And in this case, we say that it can because she has the authority to apply those waiver principles.
Okay.
And under the facts of the case, it's 6.5 months. I think it applies.
Any other questions? All right, thank you so much.
Thank you.
Let's hear from your opposing counsel. Mr. Correa?
Thank you. May it please the court, my name is David Correa. I'm representing Allegheny County. I think Justice Donahue said it exactly correctly when we were talking about, can the arbitrator do anything? Is there no authority to be dead wrong? And that's what's happened here, and that's where labor arbitration is headed to, because
I think that's part and parcel of why we have this case.
right, and that's the issue that we're coming here to do. The arbitrator is bound by the terms of the CBA. The arbitrator cannot add, subtract to, or create new terms of CBA. That's well established in the law, and the language in this agreement is very clear. If there's an issue regarding timeliness, these are the results that can go back to the last decision, or The whole idea of arbitration, or the grievance process, is that it's expeditiously pursued. So it goes forward.
Arbitrator observed that that was not the history of this case. Observance of timeliness.
But it was not the history of it because the union chose not to make it part of the history. They had every right.
Well, the history is the history.
Right, but they could have changed that history by saying, move it forward. Keep going. We don't want to do anything. We want to go to the next step. They chose not to do that. That's in the contract.
Okay, so stop there, because what you are articulating is essentially what the Commonwealth Court said the arbitrator did wrong. The Commonwealth Court said, but that's not what this contract says. I mean, the employer didn't have to do anything in this case. I mean, the way that this contract is written with the time frames, it was up to the grievant to raise issues about timeless, and when they didn't, they now can't rely on that as a point in their favor. Arbitrator came to a different conclusion. Can the arbitrator do that?
No. The arbitrator cannot amend it. It's clear why and how the arbitrator can adjust this, and it's under on page 17A of the reproduced record. It is agreed that any grievance must be presented under the procedures of this article promptly and within the prescribed time limits. Any grievance not presented with the time limitations shall be considered settled on the basis of the decision which is not appealed, or shall be deemed settled on the basis of the decision on the last level in which the grievance was carried.
But who has the authority to interpret the contract?
He has the authority to interpret the she has the authority to interpret the contract, but what she did was take this contract and turn it on its head by saying, you, the county, cannot raise this issue.
Okay, so let's say she made a mistake in interpreting the contract. Then what?
Well, it's not the mistake, but she has changed the language. She modified the language, and the case law is clear. She does not have that authority.
Well, share with us, under the essence test, the arbiter's interpretation can be rationally derived. So where's your argument that the arbiter, when she heard these facts, she rationally determined that since there was no execution of the CBA's requirement for a written consent by both parties, that there in fact was an implied waiver. And that was her rational basis for deciding.
Well,
Why is that wrong?
if there's an implied waiver, you look at the contract, what do? We go back to the last decision, which was against the union.
But what if there wasn't an implied waiver and there was a failure on your part to timely file a response within the time period? What's the remedy? I mean, could the arbitrator say, you know what, you've waived your right to assert a defense. I'm just going to award this particular award to the grievant?
No, because that's adding new language to the contract. This contract, unlike all those other cases that are cited, there is no language saying what is the remedy, what will happen if it's not raised. And I want to clarify that part of the issue here is that, I mean, the first two steps are dealt with in the department. I'm not sure that they were really looking closely at the contract. So those two no involvement at that stage. When it came to the third step, I'm not sure when I realized it happened, but under Bald Eagle, everybody agrees we go to the arbitrator for a determination on this, but the arbitrator is bound by what we have here. And the arbitrator did not follow what was here, but instead chose to create new language and say, okay, even though this says here this is what's going to happen, I'm going to say you've waived your rights.
Well, let's say you're right. Let's say what the arbitrator did here was impose a remedy for untimeliness that is contrary to the express language of the statute and therefore cannot rationally derive from the essence of it. What about the other argument, which is you never raised the timeliness issue of their appeal to the arbitration panel for 6 months until you were finally there at the day of the hearing and said, oh, by the way, Madam Arbitrator, we have a timeliness issue. isn't that procedural and purely 100% grade A, indisputably within the power of the arbitrator?
No, because I think, again, whether or not it was raised in a timely nature is a matter. There is nothing indicating what is a timely nature in the contract. So I think what
Was there anything in the contract that expressly prohibited her from making that determination, that through the arbitration proceeding, you didn't raise the timeliness issue soon enough? Is there anything contra in the contract?
Only the remedy language indicating this is what's going to happen.
If I'm saying, but that would be the remedy if you raised it timely. She couldn't give a different remedy. If you had raised it timely, then arguably under the contract, she had to dismiss their appeal to arbitration and reinstate or affirm the final decision in step whatever it was. I'm saying she's not making that determination. She's saying you didn't bring this to me soon enough. Is there something in the contract that says you can wait to raise timeliness of an appeal to the arbitrator until 6 months after the arbitration is noticed and at the hearing on the merits? That would be expressly contrary to what the arbitrator did here. So I'm asking you, is there anything in the contract that restricted her ability to decide as a procedural matter that you didn't raise the issue at the earliest possible opportunity?
I don't think the fact that that's not contained in there in the contract does not, I don't believe it can be interpreted to say, well, we're going to set our own timeline for when it has to.
Are there any rules in the contract about how arbitration should proceed, how many days, how many witnesses, discovery, anything like that?
Only the timeliness of the time schedule, and only that a grievance that's not raised in a timely manner will be what will happen in that kind of situation.
Counsel, it's called the procedure, is it not?
Yes.
The section that you're referring to is called the procedure to be followed.
It's miscellaneous
if I
provisions.
recall. Okay, I thought it started with the phrase sets forth the procedures.
Oh, okay. It is agreed that ingredients must be presented under the procedures of this article.
Well, so is that a procedural rule that binds her?
I think, and there is some case law out there that the point is that the first and timely manner of bringing this up is when you are in front of the arbitrator. It is up for the arbitrator to make that determination. So it's one of those things that I can't say without I don't know. I don't know this case.
All right, I think we understand the issue here. Are there any other questions for Mr. Carrera? Thank you both very much. Mr. Minner, we're going to take a brief recess for lunch until 12:30. Call the next case, please, Mr. Minner.
Patrick J. Carr et al. Versus First Commonwealth Bank, representing Appellts, Mr. Robert Goldman, representing First Commonwealth Bank, Mr. Thomas.
In this appeal by allowance, owners of a joint bank account filed a civil action against their bank, and the matter proceeded to arbitration. The arbitrator found in favor of the bank and also awarded the bank counsel fees. The account holders had 30 days to seek judicial review of the arbitration award under Section 7342B of the Judicial Code, which provides that upon the application of a party filed more than 30 days after the arbitrator makes the award, the court shall enter an order confirming the common law arbitration award and a judgment in conformity with the order. During this appeal period, the attorney for the account holders suffered a sudden and tragic death of a close family member, causing counsel to miss the filing deadline. Weeks later, the account holders sought nunc-pro-tunc relief, requesting an extension of time to seek judicial review, which the trial court granted, awarding the account holders 20 additional days to file their appeal. In resolving that subsequent appeal, the trial court modified the arbitration award by vacating the award of counsel fees to the bank, but affirmed the award in all other respects. The Superior Court reversed on the grounds that Section 7342B divested the trial court of jurisdiction to modify the arbitration award after the 30-day appeal period had expired, and that this appeal period was not subject to equitable tolling under the non-negligence happenstance exception to timeliness set forth in this court's 1979 decision in Commonwealth versus Bass. We granted allowance of appeal to examine the propriety of this ruling. If there's anything else to say, you can argue now. That was long. Good morning. Good afternoon.
Good afternoon, Your Honor. My name is Robert Goldman, and I'm counsel for the appellants Patrick J. Carr and his two sons, Patrick K. Carr and Daniel K. Carr. Patrick J. has since passed away, so I'm representing the two sons. Now, the issue that this court has asked my colleague and I to address is whether the Superior Court erred when it held that the trial court lacked jurisdiction to review a late filed appeal from an arbitration award when the late appeal was due to a non-negligent circumstance. More specifically, whether the court's holding in Bass permits a trial court to consider nunc-pro-tunc relief, or, as the Superior Court suggests, the common law arbitration statute prohibits or deprives the court. Well, the short answer is, under Bass, the trial court may consider nunc-pro-tunc relief even where the time limit was set by statute.
Is that the standard that you think that this court should adopt and apply, Mr. Goldman?
Yes, and I'll go into the reasons why. Bass, number one, has been the standard here for the last 47 years. This court in Bass did not make a distinction between a statutorily imposed time limit or a rules-based time limit. Bass talks about the extraordinary circumstances, and I'll read a quote from Bass. Society and the courts have recognized that events occur sometimes because of unexpected, non-negligent causes. And another aspect of Bass is that it was a five-member panel, because just like everybody else in society, this court also has unexpected life events.
So it's not a standard then, because I mean, we're in the position of having to tell the courts of all levels in Pennsylvania what the standard is, and if it's entirely idiosyncratic based on the seat of the pants sensibility of the individual judge on the individual day in the individual case, it's by definition not a standard. Isn't that right?
I understand how you're defining standard. I misunderstood it in your original question, but I will say that it is the rule, more of a guiding principle. So we do allow the trial courts to make discretionary decisions. In the Frye standard, whether the expert meets the standard generally accepted in that scientific community, we make evidentiary rulings. So the trial courts do have discretion.
The problem, and I appreciate the the analogy, but doesn't that analogy break down because unlike a fry call by the trial court, this has to do with an actual deadline. Whether the deadline's set by statute or by rule, it's not a deadline if we can't ever know whether it's going to be applied or not.
That's what Bass got to, because if we have a deadline with no exceptions for fraud, for administrative breakdown when the clerk forgets to mail the notice or he mails it to the wrong office, or for non-negligent circumstance, like in the case with Bass where the secretary was in the hospital. We have another case with Cook versus Unemployment Board of Review. That was another case where the claimant was in the hospital and was unable to file the appeal. He was late. And that was a statute. The statute said you have 30 days to file your appeal. He missed it because he was in the hospital.
See, the problem is, if I could just jump in again, Mr. Goldman, is, Justice Roberts, in his dissent in Ball, went into this, in Bass rather, and Justice Zappala, in his dissent in Cook, went into this. We had a standard. It was the standard set forth in 1938 by the Nixon versus Nixon case, and that was fraud or breakdown in the courts. And we can understand fraud, and we can understand breakdown in the courts, I think in most circumstances. But in Bass, the court called this a non-negligent circumstance, but did it not apply the lens in the wrong place? Because it looked at the secretary's illness, which was non-negligent, ignoring the lawyer's negligence for not implementing a process that would have avoided violating the time deadline.
You could make that argument, and the dissent in Bass, this is Justice
Roberts,
right, and also Zappala in the Cook case. It's kind of an ad hoc basis, and how do we determine that? And so the answer to that is, well, it's on a case-by-case basis, and it's up to the trial court to hear the evidence. You have an evidentiary hearing in every non-pro-tunc appeal to determine what are the merits, and the trial court makes that call. But the point of non-pro-tunc, then for now, is to allow the parties to be in the court when their attorneys or the clients miss a deadline. These artificial deadlines, we typically put 30 days because we just want to move the case along. But there's times, like on Bass, I had one justice was deceased, one justice had a conflict of interest, and you could only sit 5 justices on that panel. Well, everybody, we're all human, we all have lives. In my case, I had a stepson that committed suicide from my wife's first marriage, but there's so many different possible bases that could cause a disruption in somebody's life. You can't say one fits everybody. That's why you have discretion.
But counsel, you need some standard. You're essentially saying an attorney walks into a court, the judge who's hearing the case doesn't like it, you're out. You walk into a courtroom, the judge likes you, not a problem, non-negligent. That can't be correct.
Well, that's why you have the abuse of discretion standard. And
but you need a standard in order to apply an abuse of discretion. Let's talk about Bass for a moment, because I think if you go through these cases, you see what the problem is. I mean, many courts read Bass to say it was non-negligent because the attorney had systems in place in his office to make certain that timelines were met. Unfortunately, in that case, the system was the secretary who was supposed to file it was also the person in the office who was assigned to making sure the timelines were set.
Right.
So the court said there are systems in place. The attorney was not negligent in relying on that system. Let's take a case of a sole practitioner. Does a sole practitioner not need to have systems in place in order to meet the standard that's set forth in Bass? All attorneys, sole practitioners or not, are set to the same standard. So what do? Have a different standard for a sole practitioner? than we do for an attorney who practices in a law firm?
No, what I'm saying is the court should make accommodations for life's events that none of us can
No, that's
control.
not what the standard is, though. I mean, Bass actually has been read by numerous courts to say the standard, if the attorney has taken efforts within his practice to make certain that deadlines are met and the procedures fail, then that's not negligent. But if you have no procedures in your office to make sure that timelines are met, then that's negligence. I mean, that's at least a standard you could derive from Bass.
So let me just address this a couple ways. One, the abuse of discretion was not an issue. The only issue we have right now is whether the trial court had jurisdiction, because there was no appeal to Judge Della Vecchia granting the non-protunct in this case. But if we go back that far, was it an abuse of discretion, which again, not on appeal? What happened in that case, I am a solo practitioner, right? And so what I did before the appeal deadline passed, I contacted opposing counsel, asked for an extension. Extension denied. Had I got the extension, I would have been able to file it within the agreed upon time, but the extension request was denied. So now I have got to deal with the personal crisis that I'm dealing with, and then when I have the opportunity, I file my non-protunct. That's a fact that all of us, these are events that we all deal with in our personal lives. But if we don't allow for that, then I'm not allowing, like in Cook, for somebody who's in the hospital with a heart attack. I'm not allowing for the attorney who suffers a heart attack on his way to court. I'm not allowing for somebody who had a car accident. Or, as I put into my brief, what about the extreme example? What about when the court's closed because of COVID?
Isn't that a breakdown in the operation of the court?
Exactly.
Well, that. But if we take the Superior Court's reasoning, there's never a chance to, if it's a statutory timeline. So under the Superior Court's reasoning, COVID would not relieve the 30-day time limit, nor would 9/11, nor would any of those other, because that's imposed 30 days. You can't go, you have no jurisdiction. The courts can't grant it. What I'm saying is there's an extraordinary event, which is what Bass was talking about, and which is the purpose of non-protunct. Anytime you have something that's beyond the control of the parties and the attorneys.
But you see why, if I can, like, I think, and you've been candid, I think, you've been candid in saying, in resisting our request for a definitive standard, and you want it to be discretionary. And so I guess I'd ask you this. Assuming arguendo that doesn't satisfy the court, other than, in addition to fraud and breakdown of court operations, is there any other litmus or standard that you would offer arguing against your discretionary standard? Is there, or would you just decline to, you just want to stand on discretion, pure and simple?
I haven't really thought that one through, but what I have thought through is what the court announced in Bass and what has been its progeny over the last 47 years, which is non-negligent circumstance. And it's a myriad of different situations. And the trial court is given the discretion to decide whether that's a merit. Like in the one case, in Ray Chris, this court said that the attorney who missed filing an appeal on time because the mail received late was negligent and not valid. That's an abuse of discretion when the court denied it. But
why is it an abuse of discretion?
That's the appeal. So when the court,
why is that an abuse of discretion? If there's no standard that controls what is or is not non-negligent, why is it an abuse of discretion for the judge to say, you should know the mail doesn't work that way?
Right, and that's the standard. So when it's the court's call whether the attorney has set forth a non-negligent circumstance of which they had no control, and then the trial judge makes a judgment, and then it goes on appeal. An abuse of discretion would be the basis of the appeal. But then the appellate court then has to decide whether they agree or disagree with the trial court's ruling.
Hasn't that just been a recipe for a mishmash, a patchwork of irreconcilable decisions, such that the courts are basically tasked with looking case by case at whether the dog ate the homework or not. I mean, wouldn't it be of great utility to everybody across the Commonwealth if there was a standard that everybody could know? Because if it is purely discretionary, as you're saying, it's hard to imagine when we're going to find that discretion abused.
That's the point of discretion. It's discretion. It's whether the court decides what's reasonable. It's the court has to make these calls, and they're not always black and white. Some of these calls are gray areas, like life's events. So when the Superior Court questioned, and I'm going to try to tie this other part of the argument together, whether this court in Bass could issue a binding precedent when he only had 5 members and you had a 3-2 decision.
That's a binding precedent.
That's
a majority of the justices of the Pennsylvania Supreme Court.
That's how I argued it. The Superior Court said some people on the court agreed with that and some may not.
It's a matter of law. What's confused them
is that Justice Nix was concurring, and he said in his first line, I agree, I might disagree a little or something like that, but if you read his concurrence, there's no differentiation between him and the majority. So from my perspective, it is a majority ruling. I happen to think it's wrong, but it is a majority ruling.
Yeah, I mean, the number of justices on the court was not an issue. 5 of 7 is a majority. I mean, the question was, what did the concurring opinion say?
Right. I just before we leave that topic, I just wanted to read Head Note 5 from the Superior Court's opinion. To date, neither a 4-justice majority nor the General Assembly has ever permitted a non-negligent happenstance as a basis for an untimely appeal. So there was some question. But then again, that's getting to the discretion. This court says, and I agree with this court, if you have a majority of those sitting on the panel, that's binding precedence. And I think that's what the court should have followed.
Counsel, can I sort of take you in a different direction and go to the statute here? Because it's one thing to say an appeal has to be lodged within X period and nothing else, and some nunc-pro-tunc principles being applied to that. But here there's another part of the statute that I think poses a problem for you, and that is the statute says after 30 days, a party can apply to the Common Pleas Court, and that court shall enter judgment on the arbitration award. Shall.
Understand.
If we create room for a judicially created nunc-pro-tunc principle here and make that shall something else or ignore that shall, aren't we violating the will of the General Assembly?
The General Assembly has given you that authority. I'm going to refer this court back to the legislative rules. If we go back to Chapter 55, where it talks about the limitations of time. And the general sections about limitations start at 5501, they go through 5504. And what I cited in my brief was that 5504 gives this court, the legislature gave this court the power to extend the statutory timelines. And it says, at section 5504, the legislature provides that except as provided in section 1722C, which I will be getting to, the specified time limits may be judicially extended to relieve fraud or its equivalent. Now, they don't define what the equivalent is.
Well, I don't think non-negligent circumstance is an equivalent of fraud.
Well, fraud is something.
Fraud is,
I understand it's misleading.
Fraud's
it's preventing
definitely something.
It's preventing somebody from doing something or compelling them to doing something because of some misleading statement. But in the end, they are prevented from doing something, and that's essentially what non-negligent happenstance does. It prevents the attorney or the party.
But so you're saying that that provision 5504 can also be read to relieve the Common Pleas Court of its mandatory obligation to enter a judgment upon application?
I'm saying nunc-pro-tunc principle allows them to do that. That nunc-pro-tunc, what this court announced, well, it's been around since Nixon, where it said fraud and administrative breakdown. But in Bass, we added non-negligent circumstance. And I'm saying this court has the authority to create that non-negligent circumstance exception.
I don't think it's a question of the authority of the court it's a question of whether that was a wise use of our authority.
Understand, but if we don't have that, what's the alternative? The alternative is I have a statute that says you have 30 days. 9/11 comes and blows up the courthouse. How are we supposed to file?
That's a breakdown of the court operations.
Okay, so what?
A breakdown in a lawyer's, I'm not speaking about you now, I'm speaking generally. A breakdown in a lawyer's practice is not a breakdown in the court. So, by hypothesis, lawyers have the obligation to structure their practice in such a way that there's a fail-safe. Mm-hmm. So it's sort of like a lawyer, a lawyer decides he's going to go to Antarctica on vacation. He's a solo practitioner. He needs to have coverage arranged. So, anyway, that's what I'm trying to say to you is that absent a standard, we're just leaving it to what the judge had for breakfast that day.
The vacation example is a voluntary. That is not a non-negligent happenstance. What I'm talking about is the heart attack, the car accident, something that prevents the party.
You're talking about exigent.
Yes.
You're talking about an non-negligent exigent circumstance.
Yes.
Okay,
That's
so
what
what's
I'm
the
talking
difference?
about.
I'm not convinced there's any difference. I
Okay,
mean,
so-
even in lawyers plan for exigencies all the time. It's embedded in a lawyer's practice. What happens if I can't do this? Is there a fallback?
So if an attorney driving to court has a car accident and is killed, who is going to, in time, get to those attorneys' cases and find out what needs filed and when, and can take over the case and file it? If I have non-protunct, the new attorney can come in and say, hey, I just picked up this file a month ago, the appeal deadline is expired, but I don't want to prejudice the client because of something that the client had no control over. And the other point.
That's why we have legal malpractice insurance.
I wouldn't say that that's negligence if he got struck by a car or a bus.
Well, I struck by, and I'll give you, I mean, that's a tougher call.
Right, and
You're on your way into the courthouse to file the appeal, and you have a heart attack.
Okay.
That's a different situation
That's
than
the
we have
act
with
of
you.
that's the act of God
That's an
scenario
act of God.
that
Yes.
was discussed in the
Yeah.
Bass
Yeah.
case.
Yes, so what I'm getting at is if you agree that there's an exception for act of God or for whatever we want to call the non-negligent happenstance.
But see, sorry to interrupt you. Wouldn't you agree, sir, that there's a big difference? I don't know where the line comes down here, but can we agree that there's a big difference between the act of God scenario and counsel not having an adequate process in his office to ensure the thing gets filed? In other words, the Bass situation was the three-justice majority there was exceedingly indulgent of the lawyer who had this quote process unquote in place for this secretary to check her desk, and she was sick, so no fault of hers, but they let him off the hook. You see, that's not an act of God, that's an act of lawyer. And the lawyer didn't have a fail-safe. If the lawyer got struck by lightning on the way to court, that's an act of God. But the process the lawyer set up that broke down was not an act of God.
So in your scenario, an act of God acts as an exception. So I can have administrative breakdown, I can have fraud, and I can have acts of God.
I would call it an exigent act.
All right,
of
so
God. Not
those-
5 days beforehand. God
All right,
shows
so
us
as soon as this court agrees, we have another exception, whether we call it non-negligence or we call it acts of God. We've now opened up the door. Now, your question, Justice Wegg, where do we draw the line? And that's where the trial court comes in. I don't know where to draw the line in every case, but I do know we give our trial courts discretion in a lot of different areas, and this is another area where the trial court has to have an evidentiary hearing and make a call. And if the other side doesn't like that call, or either side doesn't like it, either side can take an appeal and say, oh, the judge abused his discretion. That didn't happen in this case. jurisdiction question didn't come up till 4 years later in the third appeal to the Superior Court. So the only issue before this court today is what you wrote when you granted the allowance, was whether the trial court had jurisdiction under Bass, and not going back to revisit whether trial counsel.
You just want us to look at your conduct. You just want us to look at whether or not there was jurisdiction for the court to do what it did, period,
And
regardless of the rationale that the trial court applied.
That is what this court wrote in its grant of allowance.
You're saying pay no attention to that Bass behind the curtain.
No, I'm saying I can justify what happened. I can tell you when a close family dies, and I have to go identify the body, and I have to go deal with a grieving mother, and I have to deal with funeral arrangements, and I have to deal with all these extra circumstances that I wasn't normally expecting to have to deal with. Me going to court and saying, I'm sorry, wife, you're going to have to deal with your deceased son on your own and go down and identify the body, I'll be divorced. You know, I just...
Counsel, I'm really sympathetic to the circumstances, but there were 4 days left in the appeal period.
Right.
When you were advised of these truly tragic circumstances. Why not just file an appeal? Why not just file an appeal?
I have to go to the office and write the appeal. And so what I did is I contacted opposing counsel.
4 days. Is there anyone else in your office? Do you
No.
have a backup
No,
in your office to
I'm a-
cover these kinds of circumstances?
No, I'm a solo practitioner.
Well, but see, being a solo practitioner does not alleviate an attorney's obligation to have procedures in place to deal with circumstances that arise.
Right, so what would normally
So we
happen?
should have a special rule for sole practitioners.
No, well, what would normally happen is counsel, when they run into a time, they usually call opposing side and say, hey, I have this issue. Just like Mr. Poe called me. His wife was having knee surgery, says, hey, I need an extension. Would you grant me an extension? Yes, I did. In my case, I said I had a death in the family. Can I get an
The rule's
extension?
not made for the rule's not made for the 90% of reasonable lawyers, especially here in Allegheny County. It's made for the 10% of unreasonable lawyers, right? Who are going to say, no, I'm not going to give you an extension. Lawyers have to be prepared for such scenarios, right?
Right, and so whether I had a non-negligent happenstance that would, in the court's discretion, was a reasonable reason for me to miss the filing deadline, that was left to the discretion of the trial court. So the trial court made a decision. In this case, the trial court said I had presented sufficient evidence that it warranted an extension. Question, does this court have authority to extend the statutory deadline? And the Superior Court says no. I'm saying yes, you do. The Superior Court seems to make no exceptions, even for fraud or administrative breakdown. But if you apply Bass, because the Superior Court is not applying Bass, but if you apply Bass, yes, the statutory deadlines can be extended for fraud administrative breakdown. The only question is, can we now extend it to acts of God? Can we extend it for non-negligent? And where do we draw the line? And I'm asking, I know the court issued, its issue was just on jurisdiction. It didn't ask me to prepare an argument as to an abuse of discretion, because that was never appealed, and that's not on appeal.
I'm sorry you didn't get the professional courtesy that you deserve to have in this case.
Right.
I apologize to you for that, just as a justice of this court, that there should have been a professional courtesy extended to you here.
No, I'm fine. I'm just saying, as far as the abuse of discretion, which I'm being asked about, that as existing law at the time we argued this was Bass, and I argued it under Bass. If the court wants to revisit Bass and ask to look at, well, should we consider what constitutes a non-negligent standard, that's something new that happened after the fact, and that's a question that's not before the court today. What the court has presented my colleague and I with is simply jurisdiction. And I think Bass does apply, because it applies, I think we all agree it applies where there's fraud or administrative breakdown. So we don't arbitrarily apply, hey, we got a 30-day statutory imposed time limit. There's no exceptions. If Bass applies at all, it applies to fraud and administrative breakdown. Question, can we also apply non-negligence? Well, at the time I presented the case, yes, we could. That's not before the court today. But, I mean, if you want, I would say that anything that prevents the attorney, the judge, where the one judge died, or the one judge, or any of you have a conflict and you recuse themselves, well, that's a life event that we all have to deal with. And I think those are the non-negligence standards that trial courts wrestle with. And we leave it to the trial court. If we think trial court's got it wrong, well, we can take an appeal.
All right, thank you so much.
Thank you.
Let's hear from your opposing counsel.
Sorry for your loss.
Yes,
Oh,
indeed.
May it please the court. Good afternoon, Chief Justice, Justices. I'm Thomas M. Pohl. I represent the Appellee in this case, First Commonwealth Bank. Appreciate the Chief Justice's sort of detailed recitation of the facts, because as I think everyone's probably gathered, the facts below, particularly because of the way that the Court of Common Pleas handled this case, are kind of detailed and muddy, and I want to sort of unpack some of that. Before I do, a couple preliminary items. As you know, the Superior Court here, it did three things in its March 26, 2025 opinion. It correctly reversed the May 27, 2021 order that granted nunc-pro-tunc relief. 2, it vacated the February 21st, 2024 order that improperly modified a common law written arbitration final award. And 3, it remanded for an order granting the bank's petition to enter judgment in favor consistent with the original unmodified final award. And that's consistent with 42 PA CS section 7342B, which is the statute that primarily governs here. The other statute that governs, and it's in the brief, is 42 PA CS section 7341, which essentially says that absent fraud or other circumstances not present here, the only thing that the Court of Common Pleas is to do with a final common law arbitration award is to enter an order confirming that award and entering judgment consistent with that award. So this case has been going on now for over 5 years based on really the Court of Common Pleas failure to simply follow the statute and confirm the final award.
Can I ask you this, counsel?
Yes.
If, I take it you agree that with the Superior Court panel that it's jurisdictional. Is that right?
I do, Justice Weck, and actually that touches on the next point that I wanted to raise.
Well,
go ahead.
Before you get there, is there something inconsistent? Well, either something's jurisdictional or it's not. It's not a matter of degree. It's either jurisdictional or it's not. So, assuming that you agree that extensions must be available in cases of fraud or administrative breakdown in the court, doesn't that mean that by definition it's not jurisdictional?
In answer to that question, that's where I myself have wrestled with this, because I do think the case law supports that the statute is jurisdictional. It's a matter of subject matter jurisdiction. And the law, and it's in our brief, it's been very clear that because it's a matter of subject matter jurisdiction, it's non-waivable, it's non-extendable, it's not to be modified by equitable principles like nunc-pro-tunc relief. And that goes to a comment that Justice Brobson made. Factually, in this case, when I received the phone call from Mr. Goldman, I didn't refuse to grant an extension. My response to Mr. Goldman was, Bob, I'm really sorry, but unfortunately, as the way I read this, the statute is a matter of subject matter jurisdiction. I, as an individual attorney, don't have the power to extend the court's subject matter jurisdiction. The law is very clear that parties...
That's true. And subject matter jurisdiction can be raised any time, and it's non-waivable. But what you could have done, as a matter of professional courtesy, is say, look, I can't give you an extension, but if you file late, I'm not going to object. You could have done that as a professional courtesy.
I think we're still stuck because it's subject matter jurisdiction.
I don't disagree with you, but you wouldn't be raising it. You wouldn't be raising it. Maybe the trial court raises it sua sponte, and you just say, Judge, you got to do what you got to do, but I agreed not to argue jurisdiction as a matter of professional courtesy. I could have done that.
I think making that concession might run afoul of the obligation to be respectful and professional, but to still be a zealous advocate.
Really? I think you could have joined the request for an extension and let the court decide whether it was an appropriate jurisdictional order.
Isn't it possible, counsel, to have a standard that that enforces this statutory restriction, but still allows nunc-pro-tunc relief consistent with Nixon versus Nixon in cases of fraud and breakdown in the court?
That's
consistent with our constitutional authority.
I think so, and Justice Weck, that sort of goes back to your prior question that I was addressing, which is that where I said I'd wrestled with this and that I think it's a matter of subject matter jurisdiction. I do think under Bass and the other courts that have talked about potential exceptions, fraud is a clearer issue, but that's not an issue in this case. Breakdown of the court is an easier issue to deal with, but it's not an issue in this case. And when you start dealing with non-negligent happenstance, I think it enters the realm of a standard that's so amorphous that it's not a standard at all.
I happen to agree with you on that, counsel, but what about act of God as a third
What
category?
what if your opposing counsel was struck by lightning on his way to the courthouse? That kind of.
I think there, if you do end up in a realm where some sort of acts of God or something of that nature is allowed, but the court is searching for a way to create some sort of standard, I think certainly a limit in time or a contemporaneous sort of element to the analysis would be part of what that standard would be.
Lightning bolt on the steps of the courthouse.
A great example.
Because that could apply to pro se litigants also, which is a whole different category of problems that come up. If you have non-negligence defined by lawyers' professional obligations to, take precautionary moves in their offices. So if we had an exigent act of God exception, that would apply across the board.
Well, and then does that get us to the question of, is it exigent if you're dealing with a family tragedy, an unexpected suicide of a family member? Is acting within 4 days unreasonable? And can we just leave that up to the discretion of the court?
Well, I think, and when I mentioned, the potential for some sort of time, contemporaneous and time component to a standard, it goes to that issue, and I think that's sort of what the Superior Court was doing in its analysis in this opinion, is when it was looking at and citing prior nunc-pro-tunc cases, some of which in other contexts allowed nunc-pro-tunc relief and some of which didn't. The Superior Court, I think properly so, was referring to the amount of time that passed in some of those. And you see examples like in Re CK, where nunc-pro-tunc relief was not granted, and it was affirmed that it was not granted. There was a heart attack of the attorney's mother, and he only missed the deadline by 4 days, and that was viewed as, I think, by the court not so contemporaneous in time as to constitute a non-negligent happenstance. Same in Chris v. Weiss, which is a PA Supreme Court case cited by the Superior Court. Nunc-pro-tunc was denied in that case, and there the male that was at issue only missed the deadline by 2 days. So you're dealing with examples where there was a 2-day lag or a 4-day lag, and even that was too tight. Here it was 19 days, almost 3 weeks, and that was 19 days just to reach out to the court and say, hey, I need an extra 30 days is what the request was. By the time in this case that the actual appeal was filed, 85 days had passed since the final award issued. So, again, back to section 7342 subpart B, the statute provides for 30 days. Here, the way this unfolded, it was 19 days before the court was contacted, and it was 85 days till the actual appeal was filed. And the other thing I should...
Well, I don't think the 85 days is relevant to anything, is it? I mean, we're talking here about the delay in the filing.
delay in contacting the court. I think where it is relevant, I agree with you that the biggest thing is the fact really that the tragic event here happened, and then there was a 4-day period of time in which the court could have been contacted.
But trying to decide for us to try to delineate a standard as between 2 days and 4 days and 6 days, it sort of surfaces the problem of the idiosyncrasies of this. I mean, why wouldn't I've been borrowing this act of God from like the insurance context or property damage context, because I think it's generally intelligible, right? It's the sort of the companion of the breakdown in the court, right? If there's a breakdown in the court, or if there's a breakdown in nature, right? Ostensibly, that is a basis for nunc-pro-tunc relief in a way that the secretarial breakdown in some lawyer's office is not, or even in a way that a death or illness in the family of a lawyer is not. Wouldn't you agree?
I think so, and where I sort of have been mentally coming down on this case is that if there's a line to be drawn, wherever it is, it's not in the almost 3 weeks to seek the appeal time frame. It's much closer to where the actual deadline is. The other thing factually that happened below that I think is worth noting is, if you look at, and again, this is cited in the brief, but if you look at the docket of the court below, when nunc-pro-tunc relief was ultimately granted in this case, it was granted the day the third step reply brief was filed by appellant's counsel seeking the nunc-pro-tunc. So it literally took the two-sentence proposed order that was attached at the Court of Common Pleas and just signed it. When you look at the trial court docket that's attached and cited to in the briefs, there was no hearing, no findings of fact, none of that. Really, the discussion of Bass and all of this didn't come up at all. It really, despite the fact that I was pounding on the statute that, look, this is a requirement. It's a non-waivable requirement. The Court of Common Pleas judge kind of just viewed this almost like granting a discovery extension or something routine of that nature. And I think that, I think that the proposed order was signed without a lot of thought behind it. I raise that as a point because it also brings into play a scenario that the Superior Court brought up in its opinion, and it's also in my brief, which is that this might be a different situation from a jurisdictional standpoint or from a nunc-pro-tunc standpoint if the appellant had sought some sort of relief while you were still within that 4-day appeal window, or the 4-day period where the death had occurred but the appeal window hadn't run. It might be
Did he ask you to consent to the request? Was that within the 4-day period?
I honestly, opposing counsel has represented to me that it was within that 4-day period. I can't stand here and say I recall when it was, and I've gone back and tried to look. It was at some point in that 19-day period before he actually made a filing with the court.
Well,
I'm not going to dispute it.
Did he call you to request that you join in a request for an extension or a request for nunc-pro-tunc relief?
It was a request. I think it was phrased as just a request for extension. And I know my response whenever that was that, look, I'm really sorry, but I looked at the statute. It's jurisdictional. I don't have power to extend the subject matter.
Counsel, can I just add something? I have a perspective on this. We across the Commonwealth tend to urge attorneys to extend courtesies, but in this situation, you couldn't do that here. You'd be giving up a substantive right of your client. You would have had to confer with your client before doing this, if indeed it was jurisdictional. I mean, I understand the reaction to say, why don't you just consent? I mean, if it was jurisdictional and the appeal was foreclosed, how could you agree to that without consulting with your client?
My understanding is that only personal jurisdiction can be consented to. Subject matter jurisdiction cannot.
Well, that's the legal answer.
Right.
That's the legal
but
answer.
Your point is well taken.
Well,
yeah.
I'm looking at this. I mean, there are courtesies that we expect attorneys to extend. I'm not sure one of them is to waive a substantive right of a client, at least without consulting with the client, if that's what the outcome is going to be. I mean, maybe you could have handled it a little differently, but at the end of the day, I'm not sure you could have agreed to any of this without your client saying, sure, not a problem.
I agree with that, and particularly in light of something else that was raised earlier in the questioning, which is that unlike some other situations where you have a timeline to do something with the court, in many of those other situations, it's a deadline to file a notice of appeal or whatever, and that's the beginning and the end of what the deadline is. But here it's different because the statute has a companion clause, as was pointed out, that where the legislature then affirmatively requires the court to do something after 30 days. So after 30 days, if nothing has been done, the legislature affirmatively requires that the court shall enter an order confirming the award and shall enter a judgment in conformity with the order. So, you know, this isn't just a deadline in which to file an appeal, but to Justice Donahue, to your point about a substantive right, after those 30 days have elapsed, the legislature requires that the court hear what was an order confirming an award that was, entirely in my client's favor.
This Justice Donahue's question puts me in mind of this line between jurisdictional and non-jurisdictional again, because if something's truly subject matter jurisdiction, it's not a matter, I don't believe, that is susceptible to nunc pro tunc relief. If there's something that arises in your case, and it's clear that the matter is solely available in federal court, or maybe it involves events overseas as to which we lack subject matter jurisdiction, or any number of other subject matter jurisdiction deficiencies, then it's fruitless to talk about nunc pro tunc relief. And if I'm right about that, then Superior Court, at least in its use of the terms jurisdictional, can't be right? Am I correct that if there's there's either a subject matter jurisdiction deficiency, in which case there is no nunc pro tunc relief, or we concede there is some nunc pro tunc relief, whether for court breakdown, fraud, and maybe this act of God, or call it what you will, or am I getting this wrong entirely?
Justice Weck, I agree that it's purely jurisdictional, and for that reason I agree with you. And I kind of want to make 2 points on that. One, this has been the consistent position all along, and I'm looking back to May 25th, 2021, which was the response brief in opposition to the nunc pro tunc that was filed in this case. And that's at the record at 223A to 236A. In that response opposing nunc pro tunc relief, the response was the 30-day time limit for challenging an arbitration final award has been held to be jurisdictional and therefore not waivable and not subject to equitable nunc pro tunc relief. And the citation is to Gordy, which is also in our brief, Gordy v. Vega, which is a Superior Court case where the appeal was denied by this court. So we, from the get-go, have cited to Gordy and have used that sort of soundbite that first appears in opposing the nunc pro tunc relief, and it's again in the brief that's currently before the court, but the position is, yes, this is jurisdictional, and so nunc-pro-tunc doesn't come into play.
But there are, you acknowledge that there are some situations, such as fraud and a breakdown in the courts, where nunc-pro-tunc is granted?
Your Honor, there, frankly, as I've looked at it, my position is that certainly has happened, and I think that's exactly why probably this case was taken up before the court. From my client's point of view, this court can affirm on any basis, and if this is a purely jurisdictional issue, what the Superior Court did is correct. If nunc-pro-tunc does come into play, and there's some version of non-negligent happenstance that comes into play, I think it's clear from the record here that wherever that line in the sand is and however the court deals with it, the elapse of 19 days before reaching out to the court and ultimately granting 85 days to file an appeal, wherever non-negligent happenstance falls, it's not on the facts of this case. And then
that doesn't go to whether the circumstances were non-negligence. That goes to whether they acted promptly. Isn't that the other aspect of nunc-pro-tunc? Is you have non-negligence, fraud, or breakdown, and you act promptly after the period has elapsed.
I think that's right, Justice Brobson. And I would suggest that looking at acting promptly, is part of the analysis on its own, but it also informs sort of the overall situation of is what you did negligent or not negligent. So it sort of fits into the analysis,
So
I think, a
counsel,
couple
what
ways.
is your position, if it's non-waivable, with regard to our decision of Bass versus Commonwealth? Since it's part of the Ellicott question granted, what are you asking us to do? Vacate that? Because you can't have it both ways.
Yeah, and Your Honor, to answer completely candidly and honestly, what I'm asking I'll address that, but what I'm asking the court to do is to affirm the result reached by the Superior Court, because I think that result is compelled no matter how the court rules on that. In direct answer to your question.
I was going to say, the question is, did Superior Court err? So if they err, that means Commonwealth versus Bass versus Commonwealth should be vacated in your position. I'm just trying to understand what your position is.
I think that's it, and I think where I would look sort of in further guidance is on Appellant's oral argument, he referenced Cook versus Unemployment Compensation Board, which is a 1996 case of this court. There, if you look to the dissent by Justice Apala, what he's talking about there is essentially that in Bass, the non-negligent happenstance piece is so amorphous that it's tough to figure out a standard. And so he's heavily critical of Bass for that reason, just because of the tough to define nature of that particular piece of the exception.
So we should vacate it.
I believe so.
Isn't your answer, how does your answer, would you modify your answer based on Section 5504 of the Judicial Code?
I would not, because that deals with fraud. I don't.
No, but correct. But the court does have the Judicial Assembly gave us discretion to modify the jurisdictional timelines in the event of fraud or equivalent circumstance. Mm-hmm. So even if you get rid of Bass, we have statutory authorization to still apply nunc-pro-tunc, but only in the fraud or equivalent circumstance case.
That's correct, and there I would say that,
I know you'd say, I'm not talking about the relief here.
Right, fraud is its own special thing, and that's what specifically
I'm not saying
addressed.
this was fraud, I'm just saying that getting rid of Bass does not mean nunc-pro-tunc goes away.
I would agree with that, and I would just add that the way that's written, where it sort of says the equivalent of fraud, I don't read non-negligent happenstance to be anywhere near the realm of the equivalent of fraud.
Yeah, but true. But the problem is a breakdown in the court is also not the equivalent of fraud. You could say it's worse, you could say it's better, but it's not the equivalent. Would you agree?
I would agree, and
you see the problem.
Well, I think where you end up is the facts of different cases would present harder or easier cases, as is usually the case. A fraud case, I think, would be a much clearer way to decide. The breakdown of the court's operation is somewhere in the middle. In this non-negligent happenstance, there's a reason when you look at all the cases cited by the Superior Court, why that's been the element of Bass and its progeny that the court has struggled with most, is it's just such an outlier and so amorphous compared to
and not only is it amorphous, it tastes a lot like the indulgence that the General Assembly prohibited in 5503. 5504. They said the time limit. They said there shall be no extension of time as a matter of indulgence.
or with respect to any criminal
Oh,
proceeding.
or not in criminal.
That's correct.
Okay, well, I think we get it. Are there any other questions for counsel? Thank you both very much. Interesting
Thank you.
case. Would you call the next case?
Commonwealth of Pennsylvania versus Daniel Carney, representing Mr. Carney, Mr. James Sweats, representing Commonwealth, Mr. Michael Revich.
Well, you've managed to clear out the courtroom. In a prosecution for attempted rape of an unconscious person, sexual assault, aggravated indecent assault, and other offenses, appellant asked the trial court to provide a mistake of fact instruction to the jury. The trial court agreed to provide the requested instruction for the attempted rape charge, but denied appellant's request for the remaining charges. In this appeal by allowance, we granted review to consider whether a trial court must give a mistake of fact jury instruction for sexual offenses that have, without the complainant's consent, as an essential element, where there is no allegation that the defendant used forcible compulsion to commit the offenses, and where there is evidentiary support for the defendant's claim that the victim consented to the sexual contact. Please proceed.
May it please the court, I am James Sweats. I was trial counsel and appellate counsel in this particular case. If this court follows the dissent in the Superior Court case, the question raised by the limited grant of aliquotter should be yes. Now, where did the trial court and the Superior Court in its majority decision go wrong? Look at what the trial court said in its decision not to grant reasonable mistake of fact instruction for the consent offenses. It's at 109A of the record. The court said, case law seems to indicate that the instruction would not be appropriate regarding consent. The Superior Court, in its majority decision, stated at the appendix at 47, mistake of fact about consent is not a defense to sex offenses. Both the trial court and the Superior Court were referencing the only cases that dealt with the issue of reasonable mistake of fact and consent in Pennsylvania, those being forcible compulsion cases. This case did not raise or allege in the criminal information any offense dealing with forcible compulsion. So they were wrong. Now, as the dissent in the Superior Court stated, that this is a case of first impression, in the sense that the case law dealt solely with forcible compulsion. Judge DeBow said, we have found no case that addresses whether a trial judge should instruct a jury regarding mistake of fact for sexual offenses that involve an element of consent. To the extent that a court has addressed the issue,
the Superior Court has held that a defendant is not entitled to a mistake of fact charge for a rape charge because one of the elements of a rape charge is forcible compulsion, an element for which a defendant could not have a mistake of fact. Now, the issue is where there is evidentiary support for a reasonable mistake of fact instruction and the defense requests it, must the court give it? And I submit the court must give it. And Justice Wecht, you wrote a decision, Commonwealth versus Scott, when you were on the Superior Court. And in that decision, you referenced Commonwealth versus Lesher, which was a decision of this court, where you stated that where reasonable mistake of fact is raised by the evidence and the trial court does not instruct the jury on that issue, the trial court has deprived the jury of the opportunity of adequate consideration of the defense, and the court's failure to instruct simply did not fulfill the court's obligation to provide the law to the jury. And it was reversible error. And Judge Wecht, you also stated in that decision, Justice Wecht, excuse me, you also stated
Call me what you call me, buddy, pal.
but you also stated there that what I think is particularly appropriate here, that because it would be possible for a jury to have accepted appellant's mistake of fact defense, the omission in the charge prejudiced the defendant, requiring reversal. And that's where you cited Commonwealth versus Lesher, 473 PA 141. And I believe that is the remedy that has to be followed in this particular case as well. It should be reversed, and Mr. Carney should get a new trial. One other aspect I just want to mention, because the Commonwealth said the defense didn't ask for the defense of consent. The defense instead asked for the reasonable mistake of fact defense. And they're not mutually exclusive. They were provided by the legislature as possible defenses, affirmative defenses in a criminal case. And as the court, Superior Court had stated in Commonwealth versus Hamilton, which we quote in our brief, that the legislature provided two defenses, and if there's evidentiary support for any affirmative defense, the court must instruct at the request of the defendant. And as a consequence, the argument raised by the Commonwealth simply does not carry the day, and we ask that the court reverse and grant a new trial.
Well, counsel, if you could
Sure.
just share with me, I believe my reading of the notes indicated that in your closing you argued, in essence, that based upon the compounding of the circumstance, you'll find these two people, both whom have been drinking. That's May 12th, lines 29 to 30. Doesn't that suggest that you're combining a mistake of fact with the voluntary intoxication defense?
No, Your Honor.
Right.
Let me
share with us,
Yes.
Al, based upon your language.
Yes. Naturally, the trial revealed evidence that both Mr. Carney and the complaining witness had been drinking on this raft trip. They knew each other for a long time. And and so naturally that was just part of the circumstances. It was going to come out in front of the jury. Now, the Commonwealth could have asked for an instruction, which they did not, that voluntary intoxication is not a defense. And reasonable mistake of fact, as I pointed out in our briefs, is not a reasonable mistake or a mistake viewed in the eyes of an intoxicated person, but rather an objective standard viewed in the eyes of a reasonable person, for which intoxication is irrelevant. And that's what the court could have instructed the jury if the Commonwealth so requested. And I submit that if we're granted relief here, that is how that issue should be handled at the trial level, if there's any evidence of intoxication.
Again, I'm trying to wrap my hands around. The case involved, your client argued it, or you argued it was consent. In fact, I believe you argued that the maid of honor was the initial aggressor by walking in and reaching your client's private parts.
It was a bridesmaid, not the maid of honor. The maid of honor.
Enough said.
The maid of honor was a witness.
It's an important distinction to the maid of honor.
Yes, yes.
That being said, how do you glean a mistake of fact when he's not alleging there was any mistake of fact? He argued from the get-go it was consent. Like,
well, he
based upon her intoxication, his intoxication.
No, he also stated that that he responded to her actions, and he also stated that his response was a digital penetration of the complainant. So,
which conflicted the testimony of the bridesmaid, right?
That is correct, Your Honor. And the way just as an aside, I think it's important if you read the entire record. What happened in this particular case, the bridesmaid initially said she couldn't remember anything, that she was blacking out. And what happened thereafter, when the charges were filed, and I think this is the reason the Commonwealth never touched forcible compulsion in this case. When the charges were filed, we had a preliminary hearing. We had a preliminary hearing scheduled, but they had no plan to present the complaining witness. That was before McClellan. And as a result, they were going to rely upon the police officer's statement that the trooper took at the time the complaining witness went to the hospital for the forensic examination. And what happened thereafter, the Commonwealth said, and it's reflected in the Commonwealth's brief, that they decided, all right, we're going to call the complaining witness and have her testify at the McClellan hearing. And she changed her story, or I shouldn't say she changed her story. Her story was different at that time than it was when she spoke to the troopers.
Well, she said she remembered additional details, right?
Yes, I accept that. And she began to state, well, I may have said that I recalled that he was on top of me, but no, upon further reflection, it was the other way around.
Which is what the bride testified to.
That's correct.
Which is the corroborating evidence that you're relying on, is it not? I mean, isn't that the evidence that supports the charge? There's a witness who offered evidence that would corroborate his point of view that he just responded.
Exactly. That's why when the Commonwealth says self-serving statements by the defendant, it's not really true. There's a witness. And I think most importantly, in this case,
was the man she was about to marry.
Married.
Yes, Your Honor.
But that goes
And
to
married
the
the
jury.
next day, yeah.
Yeah, and
Yeah.
married, right.
Yeah.
Exactly.
Was there other evidence besides the victim's testimony, the defendant's testimony, and the bride as an eyewitness, the bride's testimony? Was there other evidence supporting your theory of the case?
Yes. In fact, if you look in our briefs, we highlighted the testimony of Bo Norris. Now, Bo Norris, who was a cousin of the bride-to-be, but also was the ex-boyfriend of the complaining witness. And in fact, you'll see in the trial transcript that after this incident, the complaining witness went back to Carney's house there was a prearranged party, and actually rode with Carney back to the house.
But are you talking about the victim?
Yeah.
Yes. And what had happened was she heard Carney say it wasn't my fault and felt that people were looking at her as the one who precipitated this event. So she asked Bo, can you please take me away from this party? And Bo Norris did, and she spent the night at Bo Norris's house because she didn't want to be where they prearranged to have this before this incident. Now, the reason I raise that, Bo Norris testified at the trial. Bo Norris said that the complaining witness, the victim, and Mr. Carney were, and I'm quoting him, were playing grab ass along the river. And then he said, and I watched them walk up the hill toward the inn, and he used a phrase something like ride into the sunset, so to speak, or words to that effect. And so there was evidence of, however you want to phrase it, rather affection being shared by these two people.
But not necessarily evidence of consent to sexual intercourse.
No, but I think it's part of the totality of circumstances.
Any other evidence you wanted to refer to?
Well, I just wanted to emphasize here, it's always difficult to decide how would, or what's the reason behind a jury's verdict. That's always dangerous to do, and I recognize that. But Mr. Carney received his requested instruction on count 1, and he was acquitted. And the court instructed the jury that you should not consider reasonable mistake of fact on the issue of consent for the remaining charges. And he was found guilty. And as Justice Weck said when he was on the Superior Court, the court's failure to give that instruction deprived the jury of what they needed to fully deliberate the issues in the case. Thank you.
Thank you.
Thank you very much, Mr. Rukaszewski.
Yes.
And you're going to tell me if I have mispronounced your name.
That's perfectly fine, Your Honors. It doesn't matter. It won't be the first.
I want to
won't be
know.
the
I
last.
want to know the exact.
Rakaszewski.
I wasn't even close.
It's close enough.
Rakaszewski.
Like I said, it won't be the first, it won't be the last. Not a problem at all.
Let's strive to get it right.
I know you did. I know. I appreciate that. Thank
How was
you.
your drive-in from Pike County?
Monroe.
Monroe.
So pretty close. It took a while, so it was good. It was all right. It's nice country out here, though. So Michael Rakaszewski from the Monroe County District Attorney's Office. I'm just kind of getting right to the heart of it. Justice Daugherty, you were right on point. Doherty. Thanks. Oh my God, I did the same thing.
I thought it might get that too.
Oh, sorry.
Dr. Shevsky.
The whole key is if the evidence warrants the jury instruction. That's one aspect of it. Here it clearly doesn't. One of the things that's very interesting is I took a look. I wish I did it before when I did the brief, but afterwards I took a look at the actual jury instruction for mistake of fact, and it gives an actual example. The example it says is if, let's say, you go to a stadium, and I'm going from memory here. If you go to a stadium and you have a blue Ford and you park it like a stadium, I'm thinking like Pittsburgh Steelers, you go to the game, and you park your car here and you go and you come back, you see a blue Ford, matches your car, looks like it's in the same spot. You go and you try to open it and somebody thinks you're breaking into their car and you find out it's not my car. That's mistake of fact. Another mistake of fact example from some of the case laws, like let's say we're in court here today. I have a briefcase and I leave it on the chair. And then I go, and there's a lot of attorneys here, they're all left now though. But when there was other ones, and let's say we go to a break and I see a suitcase that matches mine, looks just like it. I think it's mine. I take it and I take it. And I find out, oh my God, it's not mine. Somebody comes and says, wait a minute, that's mine. I say, oh, sorry, I didn't know. That's mistake of fact. This is not a mistake of fact. This is a case this case is no different. I've been in the DA's office for like 20 years. I've done numerous sexual assault cases. This case is no different, unfortunately, than like the hundreds of cases I've done. Consent cases are usually the most difficult. They come down to one person's word versus another. You have one person who says, I didn't want this to happen, I was fighting them off, I said no, just like the victim here testified at trial. Then you have another person who says, no, they were coming on to me, they were touching me, it was consensual. It's not a mistake of fact.
Well,
there are no, yes, Judge.
You're not maintaining that what Carney believed is irrelevant, are you?
Well, what I'm saying is what he believed and what he said is not a mistake of fact. There is no mistake of fact. It's an issue of credibility. Who do you believe? And that's solely for the jury. The jury determines the facts. Another example, mistake of fact. In self-defense case, somebody has, you're arguing, maybe they pull out a phone and you think it's a gun. You pull out a gun, you shoot him. So, oh my God, I shot him. I thought he was pulling out a gun. There was a mistake of fact. You could look objectively, it's a phone, but I thought it was a gun.
Well,
that doesn't apply here.
I appreciate that, but
yes, Judge.
If I could just follow. The reason I ask is I'm wondering how the instructions that the judge actually gave got to what Carney believed and whether that belief was reasonable. I thought that was an important question, but it sounds like you're saying that's just completely off the table.
I am. I don't, realistically, I mean, I didn't do the trial. I don't think, and the judge is a good judge, I think giving that instruction for that charge was a mistake by itself. I don't think he should have ever given the mistake of fact instruction for that first charge. I don't think it's warranted. I don't think it's warranted by the case law or by the evidence. More importantly, by the evidence.
So are you saying that there's something in Section 304 of the Crimes Code that indicates that the mistake of fact defense is unavailable to the crimes at issue here?
No, I'm not saying it's an outright bar. An example where it may apply would be and I can give you an example because I was thinking about this. At first I was thinking mistake of fact in a sexual assault, whatever that can that be. An example similar to the ones I gave about the car or the coat. I'm at let's say I'm not going to use myself because I don't want to get myself in trouble. But if there's a man who's, let's say him and his wife are at a party, a cocktail party. His wife has a blue dress. She has, let's say, a blonde hair. He goes and he's doing different things. He comes over. He sees what he believes to be his wife. Blue dress, same blue dress. Blonde hair, same height, same weight, everything's exactly the same. He walks up behind her and he's feeling a little bit frisky maybe and he grabs her butt. She turns around. What is that? And he goes, oh my God, I'm sorry. I didn't know. I thought it was my wife. That's a legitimate mistake of fact.
Is that a sexual assault?
Well, that's the question. Realistically, I don't think it would be. Because,
but why not?
Well,
let's tease it out because
okay, sure.
What you're talking about is a mistake. What you're talking about is a clear mistake that negates the intent that's necessary for sexual assault.
Well, but it has to be without consent. The intent is
clearly
you're right.
without consent, but it negates his intent.
That is correct.
There's an intent element of intentionally sexually assaulting a woman by grabbing her buttocks.
But it's without consent. It's unwanted.
Yeah,
it's unwanted.
But supposing some crazy prosecutor brought that case, and defense requested the instructions that defense requested here, how would what that guy believed and whether that belief was reasonable not be something that would be instructed?
Well, maybe in a limited case like that, it may be. And I'm being candid with the court, because I was thinking about it.
It negates his intent.
Right, it negates his intent, because the whole thing, when you look at intent, almost all sexual offenses revolve around lack of consent. Whether it's a spectrum. Whether it's age, they can't consent because of the age. Whether they're unconscious, they can't consent because of that. Lack of consent, forcible compulsion. The lack of consent part a person actually doesn't even have to say no. They have to not consent, but they have to also convey that non-consent to the other person, or the other person has to, and this is in the jury instructions, and we would have to prove it as the Commonwealth. They have to either have to know it's non-consensual or consciously disregard a substantial, unjustifiable risk that it's non-consensual. So I mean, they have to do that. But the whole point is, it deals with consent. Now, the example I gave, it also has to have intent. You have to have criminal intent. And that's what that goes to the example, is there's no criminal intent on that incident. In other words, a guy is trying to be frisky with his wife, there's no criminal intent. It's not a strict liability crime. So in that case, it may be appropriate. But again, that's going to be extremely limited. Like I said, I've been in the DA's office, 20 plus years. I've never seen a case where the facts would have been similar to that to warrant an instruction. The cases yes, Judge.
Your experience in this area is years beyond mine, and that's why I look at the statute. And I'm trying to understand reasonable, if the ignorance or mistake negatives the intent, knowledge, belief, recklessness, or negligence required to establish a material element of the offense.
Yes.
Here, he was charged with basically a recklessness crime. Right?
Well, it could, well, part of it has to be intentional, knowingly, or there could be a reckless part of it to substantially disregard the victim's non-consent.
He's saying my mistake of fact as to her, he's not saying she's not saying she consented. Maybe that's part of the case, but for purposes of argument, this is sort of a separate argument, which is even if she didn't consent, I had a reasonable mistake of fact that she did consent, and therefore I can't be reckless based on the totality of the circumstances. A jury could look at the facts that I have presented and say, yeah, he had a reasonable mistake, and that negated any recklessness.
What a slippery slope that is.
But it is.
It may be. I'm just trying to rationalize with the statute in your position.
Two different things. One is it has to be raised by the evidence. So, for example, even in, let's say you have self-defense, you have to admit that you hit the other person, but you did it out of self-defense. Here, you don't have, there is no mistake. There is no mistake. Like,
well, he wouldn't testify to it, though. I mean, he's not going to get up on the stand and say, well, I thought she consented, but if I'm wrong, she consented, but if I'm wrong, then I thought she consented. Nobody's going to testify to that.
Well, no, but in my example, you could testify that I took the jacket by accident. I did take it, but I thought it was mine. I went and I tried to get in the car. I realized afterwards it wasn't mine.
Can you apply, instead of the jacket in the car, can you give me a circumstance in a sex crime situation where this instruction could be appropriate?
Sure, the one that I just gave, where if you walk up to someone who matches your wife and you think that's your wife, and maybe you grab her butt or you're feeling frisky, and you've done that in the past, and you kid around like that. In a case like that, I think the instruction may be warranted. The person's admitting.
I don't think a DA is going to bring that case.
No, exactly, because they're not going to. That's why I haven't seen a case in 20 years that warrants mistake of fact.
This is an extraordinary case.
Yes. It is. Oh, it is.
Judge DuBois, in her dissent, recounted at least some of the evidence that punitively supported such an instruction. How would you respond?
I totally disagree with that recantation. When you look at the evidence, you look at it, you have two different versions of what happened. There are two opposing versions. It's really a credibility issue for the jury.
Isn't that a jury call?
Well, it is. It has to be. It's a jury call, but the jury has to determine the facts of the case. Here, there's nothing. His statements are all self-serving. And I know you said, not said, but the counsel had mentioned about his wife being there and she backs him up. And I mean, she married him the next day. The jury obviously chose to disregard and not credit his testimony or her testimony.
About what we're talking about before the jury got the case, how they were instructed in the law.
Sure.
And, any defendant who elects to take the stand and testify is by definition self-serving.
No, I agree.
So I'm still not understanding why you're saying there wasn't. What is it about Section 304 that says categorically you can't get this instruction based on what happened?
What I would suggest is, where's the mistake? If you look at his testimony, everything's consensual. There's no mistake. He didn't mistake anything. She was the one coming on to him. There's no mistake. If you look at her testimony, there's no mistake.
I thought the claim here is that the claim
Yes.
is that he made a mistake of fact when he concluded that she consented to his sexual advances, and then he recounted all the things that happened, which I don't need to repeat here.
Sure.
So that would be, he was mistaken in thinking that she was on board.
But I see, but it's again.
Why isn't that a jury call?
It's because if you take, there's no mistake. If you take if you credit his testimony and you believe his testimony that it's true and accurate, he's not guilty. There's no lack of consent. It's clear from his testimony.
But why isn't he entitled to give the jury an optional scenario where the jury comes back and says, she didn't consent, but he made a reasonable mistake in thinking that she had.
But there isn't, because there's no factual basis for that. There's no mistake, is what I'm saying.
Her actions that he testified to,
yeah,
if they believe him,
then he's acquitted. No, he's fully acquitted.
Even if that's true, even if she came on to him, even if she grabbed his backside, even if they flirted at the reception, that doesn't equate to, well, then she obviously consented to sexual intercourse.
That's correct as well. That factors into that as well.
But they could make the opposite call as well, right?
I'm going to have to disagree with Justice Weck. I think what Justice Weck is articulating is a credibility instruction, that you could believe all, some, or none of the testimony of a witness based upon. In this particular case, what we're doing is if we were to decide in the defendant's favor that every he said, she said, non-compulsed sexual assault will require
I was mistaken.
a mistake of fact charge, which defeats the credibility charge.
I would agree with that and I would say that this would open the floodgates, because every sexual assault case, what happened is they would get all the instructions. They would say, I want consent as a defense and I want mistake of fact, because
You
little
get
yes.
that if you get evidence.
Yeah.
But that's my argument, is there's no evidence of this either. But if you open the door,
I disagree with Justice Doherty here, because I think what we're doing is, it's flip side of the argument. You're saying that these should always be a credibility determination, and what I think Justice Weck's saying is, well, if the jury is the finder of fact, they're entitled to a charge as to reasonable mistake of fact where there is evidence that the defendant reasonably believed under these circumstances that the victim consented to the touching.
and what I would say
That's not the
is,
same as consenting to the sexual intercourse.
That's correct, but
Right.
that was the rape charge.
Yeah.
The rape charge in this particular case has a forcible compulsion component to it. The jury was given the mistake of fact charge as to that charge. They found him not guilty.
But-
They were not given the mistake of fact charge as to the sexual assault charge. Therefore, it came down to, I guess, theoretically, a credibility call, as you've mentioned.
it was credibility, and the other thing too is you cannot glean any facts from juries' verdicts. Juries are inconsistent. They could issue verdicts whatever they want. They've issued inconsistent verdicts numerous times, and sometimes they, do compromise verdicts as well. And the charge in this case was attempted rape unconscious person.
But you took some, I don't mean you.
Sure.
The court took something off that table. And because, you're absolutely right. They can do all that, but, the court is disabling the jury. It's taking a tool away from the jury that arguably the evidence supported giving them.
I would disagree that it's a tool for the jury, because the jury determines, one of the things they determine are the facts of the case. They don't have to take what your personal subjective facts are or what you want the facts to be. They actually determine what the actual facts of the case are. And also how they do that too is they judge credibility as well. So I think that jury instruction, first of all, shouldn't have been given for that charge. Number one in the beginning, categorically for that. The other thing too is I think it leads to just confusion, and it invites speculation for the jury, and that's not what a jury is supposed to do.
Statutory mooring to that position, which is an understandable position. It's hard because the fact and the element and the mens rea are linked to the consent of the victim. It's hard to see how your view isn't reasonable. You're only mooring to the statutory language is that there's no mistake of fact. And that's where I'm struggling is you're saying as a matter of category that a defendant can never be mistaken as to whether a victim consents. As a matter of law, it's impossible.
What I would do is, I think my argument's a little bit more nuanced, I would say. The 99% of the sexual assault cases, it's not going to apply. The only time I would think it may apply would be as the limited example that I gave, where it's a legitimate mistake of fact. But again, the person admits
saying that it's not. I'm trying to understand why just purely on the statutory language. You're giving me like sort of this round-around thing, but you're telling me as a matter of categorical law that you cannot have a mistake of fact on consent that negates the mens rea. That has to be your position. I don't know how. I mean, you keep saying there's no mistake of fact here. That's not what I'm asking you. I'm asking you, is it categorical that regardless of what the statutory language says, mistake of consent is never, as a matter of law, a mistake of fact?
In all candor, I would have to say it's probably 99.9% never there. I can't say.
100% there because in 20 years you've never seen.
Well, you never know. Well, that's true.
But you may practice another 20 or 30 years
Sure.
and never see another case like this. But you have this case and we have this case, and I don't follow your argument that I think, to use your word, it wouldn't be legitimate. It seems you're presuming that there can be no scenario in which there could be this reasonable explanation or excuse, to use the words of 304, on this fact record to allow it to go to the jury.
I would agree with that. On this fact record, there is no reason to allow it to go to the jury. I would agree with that 100%.
That's what I just have a hard time understanding, how you're ignoring the evidence that corroborated his position that there was consent. He has an eyewitness who explains the situation, including having the complainant kissing him on the neck. I mean, you're saying that's irrelevant to whether or not there was consent?
No, I'm saying that's totally, no, it's totally relevant to consent. That's 100% on consent.
And he believed that there was consent. And
But-
that was evidence that his belief was reasonable.
No, it's not about.
Maybe it would be rejected, but
Well, no, it's a difference. It's not. That's not what it is. Mistake of fact is when, just like I had said, I gave you different examples. It's not when somebody gives an alternate factual basis. Everything he said, even if there's witnesses to it, and again, first of all, the one witness who corroborates it is his wife, and she is biased, and the jury had rejected theirs. No, exactly, and the jury rejected, but the jury rejected that testimony. They didn't find it credible.
But you're looking retrospectively after the fact finding. We're talking here before the fact finding, before the judge sends the jury out. It's a question of what arrows are going to be in their quiver. And, given the record, as it's recounted in Judge DeBoe's dissent, I don't know how you can say that the jury can get a charge on consent, but they can't get a charge on mistake. I don't see how you slice and dice it that way. The defense having requested the charge on 304, I don't see how you can say the facts didn't allow them to get that charge. It's not a matter that the jury has to buy it. It's a matter the jury has the tool.
But I disagree, and I think it is a difference, and I don't think it's simply a difference without a distinction. The jury instruction on consent goes over all different things. It goes over on whether consent's valid or not, how you know that, different things like that. It's very comprehensive. It's not subject to the individual defendant, what the defendant himself may think.
One more time,
Sure.
a different way maybe. Would you agree with me, counsel, that there is a difference, and not just a semantic one, between consent and mistake of fact as to whether there was consent?
I think there's a difference.
Okay.
And I think, though, in here, though, the issue is not mistake of fact. The issue is whether there was consent or not.
Why are you saying that's the only issue? Because that's where I like what you're saying. I'm just trying to understand, why are you saying that's the only, Justice Wecht just said there's two independent questions. You agree those are two independent questions.
I agree.
Why isn't that here where those two questions have to be given, those two options have to be given to the jury?
Because there's no basis for mistake of fact.
Well, you keep saying that, but you keep saying that, and you keep going back to that, and maybe I'm just going to have to accept that as the answer and figure this out. But are you saying that the same facts that a defendant uses to negate, to argue consent, cannot also be used to argue mistake of fact on consent?
I would say no. I would say it's different.
You're saying you can't use the same facts. So what additional facts did he need to have here to prove a mistake of fact as to consent? And you would cite me the hypothetical of he grabbed his...
That's about the only time I can think that mistake of fact could potentially be a legitimate defense in any kind of, let's say, like an indecent assault case.
What do you mean by legitimate?
What I mean by is that's the only time I could see it. Well, we'll take out legitimate, but that's the only time. Well, whether you want to say, I don't want to say rational or reasonable. People make up all different things.
Well, reasonable is the statute, and isn't that for the jury to decide?
It is, but it has to be based by the evidence. This evidence is not evidence.
Let me stop you.
Oh, sure.
I just keep thinking about, you've given several examples, the blue car one, the self-defense one.
Right.
Let me flip the switch on you a little bit. Maybe we can come to some kind of agreement. You gave an example of a guy pulled out his cell phone and pointed it, another guy pulls out his gun and shoots him.
Right.
All right? If the judge had refused a self-defense claim, or to give the self-defense charge, I mean, we all understand what that comes down to. That comes down to a reasonable belief that the defendant needs to use deadly force in self-defense, right?
Yes.
If the judge refused to give a self-defense claim, despite the fact that the defendant testified that he knew the guy was a gangbanger, the guy threatened him beforehand, the guy was known to carry a gun, had shot other people, and other witnesses corroborated that, and the judge refused to give a self-defense claim, would we be having this argument?
No, I think that would be a mistake, but that's not the facts here.
I know it's not the facts here, but it's the same issue. You're taking away a tool from the jury on a
I would respectfully disagree. It's a different issue.
What's the difference?
The difference is this is based on credibility. You have two different
But everything's
stories.
based upon credibility, because to assert a self-defense claim, a defendant's got to take the stand and say, I had a reasonable belief. If the reasonable belief is that defendant pulled something out of his pocket after he had threatened me and was pointing it at me, I didn't realize it was a cell phone. I thought it was a gun. That's a credibility determination, but you're still entitled to a self-defense charge, right?
In that case, you would be.
So what's the difference? In this particular case, if he's got witnesses, he's got his own testimony that he believes she was consenting to this particular encounter.
Here's the difference.
Why isn't he entitled to the mistake of fact charge?
Here's the difference. Here's the difference. It's exactly. It's not a mistake of fact. It's consent. It's a total defense. In other words, if you believe, it's again for the jury, if they believe his version and his witnesses and everything,
then it's
a
consent.
total. It's an acquittal. It's a total defense because it's not a mistake of fact. It's in fact consent. It's not mistake of consent. It's in fact consent.
If in fact, let me put it
Yes.
this way, if in fact the defendant, his mistake of fact charge would be brought to the jury if he argued that he was intoxicated to the point he did not understand she didn't consent.
I think
for the facts in this case, he never argued anything that there was a mistake of the intent. His defense was consent.
Right, I agree 100% with that. There was no
That's the
mistake.
difference.
Right, I agree 100% with
You
that.
cannot make a mistake of fact jury instruction when you have the defense of consent, because you're putting, it's almost like turning upside down the rape shield law.
Right. No, you're right. You're 100% right. I agree.
All right, well.
All right, thank you
we're
very
going
much,
to
Your
sort
Honors.
this out. Thank you. And next time you're back, Mr. Rakachevsky, I will not mispronounce your name.
That's enough.
Thank you.
Thank you. Have a good day.
Would you adjourn us for the day, please?